Good evening. Karen Casey, our attorney, will be reading the opening statement.
Alrighty, everyone. This is a special meeting of the Princeton Zoning Board of Adjustment being held electronically via Zoom on June 24, 2025 at 7:30 p.m. Pursuant to Section 13 of the Open Public Meetings Act, adequate notice of the time and place of this meeting has been given by prominently posting the sunshine notice of the Princeton Zoning Board of Adjustment. Such notice has been placed on the official bulletin at the Princeton Municipal Complex and by transmitting a copy of the notice to the Princeton Packet, Town Topics, The Times, Trentonian, and by filing a copy with the Clerk of Princeton on June 20, 2025, and has been posted to the municipal website, www.princetonnj.gov/meetings. Pursuant to Executive Order 107, due to the state of emergency in New Jersey regarding COVID-19, notice that during the declared state of emergency, all regular and special meetings of the Princeton Zoning Board of Adjustment will be held electronically via Zoom, was transmitted to the Princeton Packet, Town Topics, and the Times, and was filed with the Clerk of Princeton on the 24th day of April, 2020. Such notices have been placed on the official bulletin board at the Princeton Municipal Complex and on the Princeton website and are to be maintained throughout the year and by transmitting a copy of same to the Princeton Packet, Town Topics, the Times, Trentonian, Comcast Media, and by filing a copy thereof with the Clerk of Princeton. Notices have also been placed on all window doors of the municipal complex. All right.
Thank you. Thank you, Karen.
Mm-hmm.
Claudia, can you call the roll, please?
Yes, Mr. Chairman. Ms. Chen,
Here.
Ms. Coulson,
Here.
Mr. Floyd,
Here.
Mr. Shriver,
Here.
Mr. Tenenbaum,
Here.
Mr. Stein,
Here.
Ms. Donna, Mr. Dobkin,
Here.
Chairman Cohen.
Here.
Thank you.
Okay, we have one resolution and two cases. Our first resolution is 353 Cherry Hill Road, Block 4001, Lot 10, in the R2T zone. It is case number Z24-524. The resolution is in your packets. Are there any questions, comments, or if not, if someone would like to make a motion?
Sure, I'll move to approve.
Thank you.
Who was the second?
We don't
Don't
have a second.
yet.
Second, Michael Floyd.
Thank you, Michael.
Thank you.
Claudia, call the roll, please.
Ms. Chen,
Yes.
Mr. Floyd,
Yes.
Mr. Shriver,
Yes.
Mr. Tenenbaum,
Yes.
Mr. Dobkin,
Yes.
Chairman Cohen.
Yes.
Thank you.
Okay. On to the applications. Our first application of the evening is 295 Western Way, block, it looks like 8703, lot 10 in the R5T zone. It's case number Z25-638. Karen, is the noticing in order?
It is. The noticing is in order and the board has jurisdiction tonight.
Okay. Is the applicant here? I see his name.
Richard
They
Chen.
are, he's not visible yet.
Yeah, I'm here. Can you guys hear me?
We can hear you, but we need to see you too, Mr. Chen.
I don't see the option for me to turn on the camera on my screen.
Okay, do you see an icon anywhere that's or the words video?
Yeah, I can only see the word audio. Yeah, so say here, I just got a notice say join as a panelist, or join as an attendee.
There you go.
You gotta do panelists.
Okay.
Do panels. There you are.
Yeah,
Great.
so I'm here
Well,
now.
hold, Mr. Chen, hang on one sec.
Yeah,
I'm gonna swear Mr. Bridger in, because I'm assuming the board would like him to present his memo. Do you swear from your testimony this evening, Mr. Bridger will be truthful?
Yes, ma'am, I do.
Now, I see we have Mr. Lesko and Mr. Weissman here as well. Well, we'll swear them in if they make comment. That's fine.
Okay, Mr. Chen.
Oh, no, wait, Steve, do you want to hear Derek's
Oh, yes, please.
testimony? Okay.
Thank you. Good evening. Richard Chen is the owner and applicant of 295 Western Way, seeking C1 and C2 variance relief to permit the construction of a second floor addition, an exception to the required height to setback ratio. Property is located in the R5T zone, subject to the use regulations, bulk regulations in section 10B. A 246, 253, 255, and 255.2 of the former Princeton Township Land Use Ordinance. The subject lot is non-complying with regard to the required 21,780 square foot lot area. The existing lot is 7,792 square feet. It's also non-compliant with the required 100-foot lot width requirement. Existing is 65 feet. The applicant is proposing to construct a two-story addition to the rear of the existing home. The addition will expand the family room and kitchen and add a full bath and office on the first floor, and the second floor will feature 3 bedrooms, sitting room, and 2 full baths. The proposed two-story addition does not comply with the required height setback. The left side requirement is 1:1, and the proposed is 1.25:1. The right side has the same requirement and is 1.30:1. The applicant has requested consideration under the C1 and the C2 criteria. If you have any questions, I'd be glad to try to answer them.
Board members, any questions of Mr. Bridger? Okay, Mr. Chen, please present your case.
yeah, so
Mr. Chen, I just need to swear you in. Do you swear or affirm your testimony this evening will be truthful?
yes, I do.
Thank you.
Hi, hi everybody. I thank you, Mr. Bridger, and thanks to chair and the board members for your service. So I'm a homeowner of the 295 Western Way, and maybe I have a few slides I would like to share with the board. If I can I just project from my computer?
Yes, if you can.
Okay.
Share your screen.
Yeah. So can you see this? Oops. Can you see the PowerPoint slides?
Yes,
Yes, you
Okay.
can.
Yeah, let me just figure out the pointer options.
Mr. Chen, do you know how many slides you have?
I have 7. I should submit the PDF file of this.
You did. Okay, that's
slides.
great.
Yeah.
Well, why don't we say collectively, these are your exhibit A1. So we'll
Okay.
all right, great.
Yeah. Yeah, maybe just before I present my case, just say a couple words for myself. So I'm a resident, a Princeton resident since 2005. Actually, being a long-time Princeton resident is a great place for me, for my family. And the 295 Western Way is my the second house I have owned, and we sold our previous house, so sort of downsizing to the current location. And I work locally at with this foundation as a science director. So it's a great situation for me. So I would like to renovate the house for myself, and currently for two of my daughters who currently live with me, but going forward, I would like, well, I probably would use this as I will use this as my primary residence, and for myself, and then maybe for my kids to occasionally visit me. So the renovated house will have a 3-bedroom and 3 full baths, and an office and a separate office. I think it's going to be a great space for myself and for my family. So Mr. Bridges said that this is a C1 and C2 application, but as you will see, I will probably say, to my understanding, this would be probably the typical C1 and C1 hardship application due to the narrowness of the lot. So on this slide, I hope you can see that this is just the copy from the township map. That the red rectangle here is the 295 Western Way, and is on the border, I believe, Cedar Lane and North Harrison and the street. And again, this is this R5 zoning, as Mr. Bridget mentioned, that the current lot and most of the lots actually in this R5 zoning are not conforming, and those lots along the Southern Way and Western Way are particularly small. So in my case here, the zoning requirement is around 21,000 square feet, and my lot is around 7,800, and the required length is 100, and my lot is 65. So it's a very narrow lot. And this slide just shows so like the Google Maps showing that. I just give you so like a rough idea what the renovation going to be. So the renovation going to be near the rear end of the house, and we'll be removing a current structure that has the first floor, so like a family room, and the second floor like a exposed patio deck, which is now pretty much damaged. So the replacement will be a little bit extension of this thing would be a two-story renovation, and in addition would be you have a new deck in the back of this addition, and then entrance to the basement. Actually, again, as Mr. Bridger said that just a while ago, the required height to setback ratio is 1:1. My proposed work of this addition would be 1.25/1 on the I believe on the left side of the house. Left side of the house would be this side of the house, and then 1.3:1 will be on the right side of the house, will be this side. Please interrupt me if you have any questions. So this slide just show you also like a snapshot of the overall footprint of the house. This on the left side is the current survey, the survey of the current house, and this one will be proposed footprint of the with the addition, so that I put them side by side in approximately the same scale, and I draw a few like lines just to show the so like the overall match in the front, middle, and end. You can see from here is that the overall footprint of my proposed addition won't change much, almost at all from the existing footprint. And this slide just show you the sort of like the front shot of the house. The on the left is just the existing house look, and on the right is the computer rendering of the front elevation. And the overall structure won't be changed at all. I will just replace the window siding and the garage door, maybe replace the front porch. So the front structure will not be changed. And then on the two sides, that's where the variance is being sought. So on the top panel, you see the left side is the garage side. That this is the existing look, and this is just the side shot of the computer rendering, and the new wall here is from the approximately from this green line here. This will be the new wall, and some of the walls on the first floors already existing, but the new in terms of second floor will be new wall on this side, and this will be a deck space here, and the lower panel. If you look at will be the right side. Again, this picture here is a real a time picture from the existing, that's the chimney side. Is that this is going to be the existing wall almost to here. Again, it's approximate, and the new wall will be added here. And again, some of the existing first floor already existing, and then the new wall will be the second floor all the way to this end. And due to some requirement that I cannot have a continuous wall longer than, I believe, 25 feet. So this you will have a little bit dent into the middle of the house. So this wall is continuously not longer than 25 feet. And this is a thing. This is really the where the numbers can come from. This is the rear end shot of the elevation that would be the proposed. That again. So this is just existing the wall from so like extended from the existing wall. That's the setback, and that's the height. And again, that's how the ratio calculate, and the both the green highlight will be the variance I'm applying for. And this will be most of my presentation. And then the last slide, I just want to make a confirmation statement here is so-called I read the instruction. I need to confirm that the renovation, the variance won't have a negative impact. So I would like to say that the variance, if granted, will permit of the proposed addition and renovation, which one that will bring a very old house in poor conditions to modern living standards while retaining an overall appearance consistent with the neighborhood. So I would like to ask that is true, which I believe is true. And then the second is that this renovation will not bring detriment to the public good. I'm not changing much. It's more like a renovation with a small addition. And then I also would like to say that this will not impact the intent and purpose of the current zoning plan and for the neighborhood. So I would like to end here and thank you for your attention.
Thank you. Board members, do you have any questions of the applicant?
How would I see like end show? Hold on, sorry.
I guess my only question, Mr. Chen, so basically both sides of the house will not be any wider than they are now.
That's
or
true.
any closer to the property line. So this is basically just a height to setback situation because the existing house didn't conform as well.
That's true, Mr. Chairman. Yeah.
Okay. All right. That was the only thing I had.
I have
Board
one
member?
question. Yeah.
Go ahead, please.
Sure.
I'm just confirming, is it correct, Derek, that you established the height to setback? The height is established based on the bottom of the eave, is that correct?
It's a
That's what I
close-
see dimensioned.
The eaves are accepted, but it's the closest wall, so you're allowed a 3-foot exemption from the eve of the wall, but it's actually the height of the walls where the 19.6 is on the left
Okay,
side.
okay, so that's correct.
Yeah, and it's actually the same on the right side. It's
Yeah,
19.6,
okay,
but
I
the
just wanted
setback
to,
slightly
clarify.
changes.
thanks.
Correct, sure.
Thank you, Derek.
Any other questions, board members? Okay, Mr. Chen, what we're going to do, if there are no other questions from the board, we're going to open this up to the public for comment. Before we do that, do you want to add anything to your presentation?
Maybe actually, so I actually know through a mutual friend to one neighbor on my right hand side, Mary and L, and I got to know the other neighbor. So I got a chance to talk to both. Actually, Mary and L were on vacation. I emailed them the application, and we had email exchange, and I had a conversation with the left side of the neighbor, Stuart and Beverly, and I explained this situation to them, and these are neighbor were, and both neighbors very nicely said that they have no objections, and I wish me well.
Okay. Unless we have a statement from them, it's nice to know that, but it doesn't do a lot of good.
Okay, yeah.
Okay, no problem.
There is a hand raised, I believe. I thought I saw one in the attendee.
Okay. Yes, Claudia, do we have anybody who would like to speak? We'll open this up to the public at this point.
Mhm.
Claudia, has anybody you're muted, Claudia. Has anybody indicated they'd like to speak on behalf of this application?
I have one member of the public and he's moved over.
Okay,
There he is. Mr. Liverman?
Yes, can you see me?
We
It says,
yes, we
can.
can.
Mr.
good-
Lieberman, could you, do you feel comfortable giving us your address?
I certainly do. I'm one of the neighbors. 301 Western Way, Princeton, New Jersey. I do swear and certify to tell the
Okay.
truth, the whole
Thank
truth, and
you.
nothing but the truth.
Thank you.
Good evening, everybody. My name is Stuart Lieberman. I live at 301 Western Way. I'm Richard's new neighbor. What he stated to you is absolutely true. We completely, wholeheartedly endorse this application. It is a narrow application. It clearly satisfies the requirements for a C1 variance because of the narrowness of the property. And also, it satisfies the positive and negative criteria without any question. The property is run down. It served for many years as a wonderful structure, but because the person who was living there was old, she wasn't able to take care of it. Richard's going to make an incredible, wonderful improvement. Not only is he a great neighbor, but this is going to be a wonderful improvement, and it will do no negative to the community or to the neighbors because the side setback lines are identical. So I wholeheartedly endorse this application, and I do ask the board to approve it in its entirety. Thank you very much for your courtesy. In case you have any questions, I have nothing else to say. Hi, Eve. How are you?
Well, Mr. Lieberman, I think you like it. We understand that.
That's exactly
Yeah.
right. Thank you. You're right. You got it. Thank you, board. I appreciate your courtesy and I appreciate your volunteer too.
Okay, Claudia, has anyone else indicated they'd like to speak? Claudia? You're muted still.
I don't see any.
Sorry,
other
I'm having
hands. Thank
issues
you.
here. There is no more hands.
Okay, since we have no one else that'd like to speak, we'll bring the public portion of the hearing to a close. Again, Mr. Chen, before we go into executive session where we discuss and make a decision on the application, do you want to say anything else?
No more. Thank you.
Okay.
Thanks everyone.
Welcome. Okay, board, we'll go into executive session now. Comments, questions, motions? Seems like a fairly straightforward situation. I went by the house and it appears to be in need of a lot of work. And I think looking at the drawings and hearing Mr. Chen, I think he's going to really improve it. So I would support the application.
I agree with you, Steve.
Yeah, I agree as well. It's just keeping the same roof lines. I don't see an issue.
Yeah. I agree with you too. And the house is a lot shorter than the maximum height. There's a lot less coverage, impervious coverage than is permitted. And it's even just below FAR. So it's pretty modest.
Any other comments, or would someone like to make a motion?
Yeah, I would just say one thing to clarify. On the site plan, all the setbacks are called out as 15. So I think one of them is actually supposed to show 15.7 on the site plan on the drawing. I just noticed that. But otherwise, I move to approve it on sheet Z1 site plan.
Second.
Okay. Questions on the motion? Okay, Claudia, can you please call the roll?
Ms. Chen,
Yes.
Ms. Coulson,
yes,
Mr. Floyd,
Yes,
Mr. Shriver,
Yes.
Mr. Tenenbaum,
Yes.
Mr. Stein,
Yes.
Chairman Cohen.
Yes,
Thank you.
I just lost my connection. Can you hear me?
Yes.
yes.
Okay, good. Well, you can't see me, but you can hear me.
No, we can
So-
see you.
Oh, you can? Okay,
Yeah.
I can't see you guys, but it's fine.
Oh.
I remember you all. Okay, our next hearing, we'll move forward. Our next hearing is case number Z 25-623. 728 Bund Drive, block 2901, lot 11, in the Office Research District. What is that? OR1 zone. Karen, are all the notices in order?
Yes, the noticing is in order. The board has jurisdiction to hear the application.
Okay, good. I think, Mr. Bridger, can you present your memo?
Yes, sir. Thank you.
Thank you.
TRU Princeton LLC is the owner and applicant of 728 Bund Drive. They are appealing my interpretation, the zoning officer's interpretation of a zoning ordinance requiring site plan and conditional use authorization to permit a drug and alcohol rehabilitation facility in the location of the former Princeton Care Center. The applicant filed a zoning permit on February 14th, 2025, seeking approval to permit the use of the site as a drug and alcohol rehabilitation facility. Zoning permit was denied on February 26, 2025, at which time the applicant was advised that a site plan and a conditional use authorization were required to permit the change in tenancy/use. The site is the home of the former Princeton Care Center, which operated as a nursing home. The center was abruptly closed on September 3rd, 2023, due to financial mismanagement, and the center was suspended from New Jersey Medicaid on March 28th, 2024. And the site has been vacant since the closure. Subject property is in the OR, or Office Research District 1 zone, and is subject to the use and bulk regulations in accordance with sections 10B 246 and 268 of the former Princeton Township Land Use Ordinance. The nursing and rehabilitation use is listed as a conditional use in accordance with section 10B 272.4. Property is surrounded by following land uses: a medical office building to the north, Bund Drive across from the Institute of Defense Analysis, open space, Princeton Community Housing and Residential Development to the east, and Campbell Woods and residential townhouse development to the south, and residential single-family dwellings to the west. In terms of prior approval, major site plan conditional use authorization and related variances was filed by the Princeton Care Center with the Princeton Planning Board, and it was approved on February 25th, 1995. A copy of the resolution and findings of fact are in your package. 2 variances were granted, parking variance to allow parking lot containing 47 spaces, whereas the ordinance limits parking lots to 30 spaces. The second variance was granted, permitting certain parking spaces to have a length of 18 feet versus 19. The approval was granted to permit the construction of a 3-story, 119-bed nursing home. The building is a Y-shaped building containing a 21,628 square footprint and a total area of 64,844 square feet. Site improvements include 60 parking spaces to the north and west of the building and a detention basin. The approval also included 20 bank parking spaces. In terms of the appeal of my interpretation, the applicant's position is that the previous nursing home and rehabilitation center use is essentially the same as the proposed drug and alcohol rehabilitation center, and that a site plan application and a conditional use authorization are not required or applicable. Section 10B 320 of the code contains a table of allowable conditional uses in the municipality. The uses listed as conditional uses are only permitted after approval is granted by the planning board in accordance with the provisions of this section, and only if the regulations applicable to the district, except as modified within that section, are complied with. The table of conditional uses identifies nursing homes and assisted living residences as a permitted conditional use in accordance with section 10B 272.4. Nursing home is defined in that section 10B 201 definitions as a facility which is licensed by the Department of Health in accordance with NJAC 8:39 to provide healthcare under medical supervision and a continuous nursing care for 24 or more consecutive hours to patients who do not require the degree of care and treatment which a hospital provides, and who, because of their physical or mental condition, require continuous nursing home level care. The municipal zoning code does not specifically define a drug and alcohol rehabilitation facility. The applicant presents a planning opinion that makes the argument that the 2 uses are so similar they are essentially the same. The proposed facilities use generally complies with the nursing home definition above. However, the licensing requirements are not the same. The proposed use differs from the previously approved use in the following manner. Number 1, there's an increase in the number of beds. The original approval was for 119 beds. The applicant's proposal is for 148 beds. This is an increase of 29 beds. While this is within the ordinance allowance for the number of permitted beds and units, it does represent a significant increase over the previous conditional use approval, and the parking requirement for nursing homes is based on section 10B 272.44, which states that no more than the number of off-street parking required to meet the needs of the residents, employees, and guests shall be allowed. The applicant shall submit a parking study prepared by an expert to justify its need for the proposed number of spaces. The applicant's proposed number shall not exceed the number produced by applying the following standards for determining the number of required parking spaces. A, 0.30 spaces per nursing care bed or assisted living bed, 1 space per staff member on the maximum shift, and C, an additional 10% of the sum of A and B above. The additional requirement of section 10B 291.1 shall apply. The parking lot has 60 spaces. The condition requires, as I said earlier, a parking study by an expert to be submitted to justify the maximum number of spaces on the site. The nursing home and the proposed rehabilitation center have different licenses. Section 10B 272.4A requires that a nursing home approvable as a conditional use must be a facility in a multifamily structure, which is licensed by the Department of Health in accordance with NJAC 8:39 to provide health care under medical supervision and continuous nursing care for 24 or more consecutive hours to patients. The proposed drug and alcohol use requires a subacute, non-hospital-based residential detox and short-term residential substance abuse treatment license for adults only in accordance with NJAC 10:161A et al., which is issued by the New Jersey Department of Health. This is a different license from the required for a nursing home and is an exception to the conditional use section 10B 272.4080. 10B 272.4J addresses the conditional use requirements for nursing homes. The only provisions of this chapter which shall be interpreted as conditions for the conditional use are subparagraphs A, B, and C of this section 10B 272.41. And section A requires a nursing home be approvable as a conditional use. It must be a facility in a multi-family structure which is licensed by the Department of Health in accordance with NJAC 8:39 to provide health care, medical supervision, and continuous care for 24 or more consecutive hours to patients who do not require the degree of care and treatment which a hospital provides and who, because of their physical or mental condition, require nursing home level care. For the purpose of this subdivision, nursing care beds are approved beds in a nursing home which are used or available for patients. The room is in a nursing home in which 2 or more nursing care beds may be located are designated as nursing care units. Nursing home level care means care provided to individuals who have chronic medical conditions resulting in moderate to severe impairment in physical, behavioral, cognitive, and psychosocial functioning. It includes, but is not limited to, partial or total assistance with activity of daily living, assistance with self-administering or administration of medication, and provision of treatments and periodic reassessments as directed by the patient's plan of care. It also includes the provision of physiotherapy, occupational therapy, therapeutic counseling, and rehabilitation services as indicated by the patient's medical condition. 3, a multifamily structure is a building containing 30 or more care units with each sharing with another unit or units, 1 or more vertical common walls, and with each having its own separate entrance from an interior hallway or common area. The other criteria are conditional use standard it relates to assisted living, which I do not believe is applicable in this case. And then C, the last condition for conditional use standards is to qualify for conditional use approval. The applicant must demonstrate that the nursing home or assisted living residence has received or will be eligible to receive a license from the state of New Jersey Department of Health pursuant to the provisions of applicable states and regulations. As I note, the licensing for the 2 uses, the rehab center and the nursing home, are different. This is considered a deviation from a conditional use standard and accordingly a variance in accordance with NJS 40:55D-70 D3 would be required. In addition, site plan would be required as well. Section 10B 205, which addresses when site plan approval is required, states that no use shall be changed without site plan approval. In addition, section 10B 34 requires that the application for a conditional use authorization include any related site plans. In conclusion, it's my opinion that the proposed drug and alcohol rehab center use differs from the previously approved nursing home use in the following manner. The proposed use does not meet the conditional use standards of 10B 272.40A, and the proposed use increases the number of beds in exception to the previous approval where 119 were approved and 148 are currently proposed. And site plan review is required pursuant to section 10B 205 and 10B 34. For the aforementioned reasons, I believe the request for the approval of this new use by the submission of a zoning permit does not allow for sufficient review of the proposed use and site conditions. The applicant could move this application forward by filing a major site plan and conditional use authorization and a variance pursuant to NJS 40:55D-70 D3. In accordance with section 10B 272.44, the applicant shall submit a parking study prepared by an expert to justify the proposed number of parking spaces. That's my memo. If you have any questions, I'd be glad to try to answer them.
I have a
Thank you.
question.
Yes, sir.
If this were just going to be a nursing home, as it was before, would our only discussion be about the parking spaces and the extra beds?
I'm not sure it would be here, if it met that conditional use criteria.
Okay, so it's really just changing its purpose.
It's the license difference is
Mm.
the main,
Mhm.
it's a conditional use criteria, which they
Mhm.
don't explicitly meet.
Steve, you're muted.
I know, I was thinking, but you apparently read my mind because I didn't even open my mouth yet, but I was thinking of saying something, which is I'm confused as to why this has come before zoning, because it almost seems like it would be a different body that would be
You
approving.
mean the planning board?
No, we're the zoning board. I'm
No,
surprised.
I know that, but are you saying that you think it belongs before the planning board?
Maybe, I'm not sure. I mean, I don't see anything inherently. On the one hand, I mean, leaving that aside, from what's been put forward by everything that I read from the applicant, it in some ways seems like I mean, it's sort of a mixed bag. There are more people, but from what I read, none of them who were staying there would be allowed to either drive or have a car there. So the parking issue seems, if anything, less of an issue than it would have been if it were a nursing home.
Well, Eve, I'm not going to speak for Derek, but my understanding is that nursing homes are permitted as conditional uses in this zone. And pretty much the only criteria under the ordinance for the nursing home is, does it have a license from the state of New Jersey? So Derek has interpreted this to mean the applicant would need relief from that. Yes, their position is these uses are so similar that it's very hard to distinguish between them. But as zoning officer, Derek's interpretation was, well, perhaps, but this is a condition they can't meet. Whenever an applicant can't meet a condition of a conditional use, they have to come to the zoning board for a variance. The planning board can't issue that variance, the zoning board can. So with Derek's interpretation, he's concluded that, this is the board they need to be before. Now, I'm not going to speak for the applicant either. The applicant is here tonight with professionals to explain to the board why they feel they don't, this isn't necessary.
Karen,
So, yep.
Karen, isn't the answer to her first question, it's here before us because zoning and municipal land use requires the appeal to come to us when you
Correct.
appeal the zoning officer. That's
Correct.
the answer to your question. That's why it's here. There's no other option.
Correct.
If they want to appeal.
I
that's what she
yes.
asked.
Yep.
Okay,
Thank you.
any other? Sorry. Anything else?
No.
Okay. Any other questions, board members, before we allow the applicant to make his presentation? Okay, who's going to represent this case before us, and are all your witnesses here?
Yes. Good evening, Mr. Chairman, members of the board. My name is Michael Lario. I'm a partner at the firm of Nemad Davis and Goldstein. I'm here this evening on behalf of the applicant, TRU Princeton LLC. This application, just for the record, concerns property at 728 Bunn Drive. It's block 2801, lot 11. It's approximately 6.272 acre site entirely within the OR Office Research Zoning District. As was stated, we are here this evening to appeal the February 26, 2025 determination of your zoning officer, specifically the denial of a permit for the operation of a licensed drug and alcohol rehabilitation facility at the subject property. This appeal is brought pursuant to NJSA 40:55D-70A which authorizes this board to act in a quasi-judicial capacity and address a misapplication of law. The determination at issue before this board this evening constitutes whether the establishment of that drug and alcohol rehabilitation facility constitutes a change in use, requiring site plan approval and conditional use authorization. We believe that that conclusion is incorrect as a matter of fact and law. As was stated, the subject property was previously utilized as a licensed nursing and rehabilitation center under approvals granted by the planning board back in 1999. It was purpose-built for that institutional medical use. The improvements include patient rooms, nursing stations, dining facilities, kitchen facilities, common areas, all necessary medical infrastructure for that proposed nursing home use within this existing approximately 64,000 square foot building. The Princeton Care Center ceased operations in 2023. It was soon thereafter purchased by the applicant, largely because of the existing institutional healthcare improvements at the subject site. Now, with the present proposal, the applicant is not proposing any changes to the site itself. The applicant intends to operate this use entirely within the existing building footprint and the existing infrastructure. The proposed use of subacute non-hospital-based residential detox and inpatient treatment center is functionally and operationally equivalent to the prior nursing home use. Both uses require 24/7 medical supervision. Both uses are licensed by the New Jersey Department of Health and regulated by the commissioner. Both provide residential healthcare in an institutionalized setting. From a zoning perspective, there is no meaningful distinction between these two uses. And this will be established through our professional and expert testimony here this evening. While the applicant is proposing a modest increase in the total number of beds from 119 to 148, this is entirely consistent with what is permitted under your ordinance. Individuals in this facility are prohibited from having vehicles while they are within this facility, and visitations are extremely discouraged by the staff. Our professional testimony will show that the parking currently on site, the parking that was approved in 1999, is more than adequate to meet the anticipated demand under your existing zoning ordinance. Critically, you'll hear testimony this evening that state law recognizes nursing homes, hospitals, and rehabilitation treatment facilities as inherently beneficial uses. These are uses that are deemed to be so important, so encouraged, that municipalities should look to include them in every community. And I think that classification is particularly important here when you're talking about an institution for addiction recovery. New Jersey, like many other states, is currently going through a public health crisis here, a widespread addiction crisis. Facilities like this one are not just beneficial, they're critical for addressing this public health crisis today. As indicated, while existing case law classifies nursing homes, hospitals, rehabilitation facilities as equivalent uses from a zoning perspective, it does permit municipalities to provide for use standards in their ordinance. They can regulate them through the ordinance provisions. Princeton has done that. Through section T10B 27240, you have provided a list of conditional use standards for these types of nursing home uses. And I would add that a rehabilitation facility is not a term that is included in your ordinance. So we look to nursing homes here and the standards contained therein. You will hear testimony from our professionals that we meet every applicable condition within that ordinance. Now, there is a slight difference in the licensing citation under your ordinance. One for the nursing home, the other for the proposed residential rehabilitation facility, but both are issued by the Department of Health. Both provide for 24/7 medical supervision, and they both contain the same oversight and regulatory framework. They're materially the same license required for each uses. It's only the class of individuals that is being served by these licenses. Nursing home is for elderly individuals. The proposed rehabilitation facility license is for those in addiction recovery. I would note that federal law requires that people with disabilities, including those in active recovery, recovery from drug and alcohol addiction, be treated equally under the zoning law. Both the Americans with Disabilities Act, the Federal Fair Housing Act, they classify such individuals, those in recovery from drug and alcohol addiction, as disabled individuals as a protected class. The FHA also requires that this board and local government make reasonable accommodations for these individuals to allow them equal access to housing and services. Denying the use or attempting to differentiate the use based solely on the class of people provided for under the licensure violates both the Federal Fair Housing Act and the Americans with Disabilities Act. By prohibiting this facility to move forward by instituting regulatory hurdles on the applicant based solely on the population it will serve, will work to deny people within this protected class, within this disabled class, the housing and care that they need. It would expose municipality to potential liability, including damages and fee shifting provisions. And with our testimony tonight, you'll hear from our professional engineer, you'll hear from a licensed psychologist, you'll hear from our planner and a representative of the property owner, which through their testimony will demonstrate that the proposed use does not intensify the site activity in any way. It does not require any physical changes to the building or to the site, and does not adversely impact the surrounding area in any way. What it will do is take a currently vacant institutional medical use and allow for a much needed and productive use of the site. For all of these reasons, legal, practical, equitable, we respectfully request this board reverse the zoning officer's determination and confirm that no site plan is required and no conditional use approval is required. Now, I have with me this
Mr. Lara,
Yes.
And Mr. Chair, may we ask a question now, or would you like us to wait?
Well,
a
why
moment?
don't you, well, you want to finish, you want to allow the attorney to finish his presentation, and you can question him before the other
Or
witnesses.
I'm sorry, I thought he was about to call.
So,
some witnesses. Okay.
My opening is concluded, Mr. Chairman. I'm just going to go through my witnesses who I plan on asking questions for and then have them sworn in. So,
Okay, let's do that. Let's do that, and then we can,
Okay.
then Harlan, you can ask your question.
Thank you.
So with me this evening, I have Olivia Kono-Niyuk. I have Dr. Allison Tarlow. I have our planner, Andrew Janow, and I have, on behalf of the applicant and owner, Mr. Carl Kaplan.
Okay, Karen, do you want to swear in the witness?
Well, so I may mangle your names, but I will try. So Mr.
Can the people asking to be moved over, can they raise their hands?
Okay. I don't think we can see everyone though. There's Ms. Zhao, but we can't see her and she's muted.
Well, is it Irene Zhao? She just,
Dr. Tarlow, I just saw her pop up, her name.
Yeah, we just can't see her. Let's see. And now
Hello there.
there she is. There's Dr. Tarlow. And then there's Ms. Zhao. Is that one of your witnesses too, Mr. Lario?
It is not, no.
It is not. Oh, okay, fine. So we have Mr. Kaplan, Ms. Koniak, Dr. Tarlow, and Mr. Janu.
Correct.
Right? Do you all swear or affirm your testimony this evening will be truthful?
I do.
I do.
Thank you.
Okay. Harlan, would you like to ask your question now? You did, Harlan.
Sorry. Thank you, Mr. Chair. Going back to the opening statement, my ears kind of pricked up when I heard the terms damages and fee shifting provisions. I was hoping that council could please highlight what that was or what was meant there. It was kind of read rather quickly. I just want to get a better understanding of that, please.
So again, when you're discussing those individuals in recovery from drug and alcohol addiction, they are protected classes under the law. They're classified as disabled individuals under both the Americans with Disabilities Act and the Federal Fair Housing Act, and that entitles them to certain protections from the law. We believe that really the only distinguishable characteristic here between a nursing care use and the proposed residential facility is the class of people that is being served here. That it is those in recovery from drug and alcohol addiction would be prevented a reasonable accommodation and essentially provided additional regulatory hurdles that are unwarranted under the law. Now, if that is found to be the case, there are fee shifting provisions and damages provisions applicable for a violation of the Americans with Disabilities Act and the Federal Fair Housing Act. And again, I say that obviously on behalf of my client, but I think it's important for the board to know as well, in dealing with these disabled class of individuals, if a violation of their rights under the ADA or FHA is determined, they are entitled to that relief.
Okay. All right, Harlan, does that answer your question?
Yeah, thank you.
Okay. All right.
Mr. Chairman,
Yes.
Chairman.
Yes, please, Michael.
Yeah, I kind of had the same type question, because I heard what he said. And damages. Are you, Mr. Lario, asserting that both Mr. Bridger's decision and if we concur with Mr. Bridger's decision, that this stops here, that you're not just going to proceed and put in an application to be heard like most other applicants? Or because we are not stopping the use here tonight. It's not even close to the end. What you do and what you will do, because it's probably in your plans, you'll just go to the planning board. Is that not correct?
So two things, Mr. Floyd. I think once our professionals go through their testimony, you're going to see that this is a situation in which this board can grant the request for relief because there is no distinguishable difference between the nursing care use that was previously approved.
No, I heard that before. My question is very simple.
Mhm.
You're basically asserted that we and the municipality would be liable if we don't see it your way at this point tonight.
So I think to
Are
your
you saying that?
So
I'm
what
sorry. Are you saying that?
What I'm saying is that if a determination is made that there's a violation of the rights of this protected class, yes, the municipality could be responsible for damages.
Okay, I will leave you and go to our attorney. Do you have any observation or statement on his statement that after tonight we could be liable and the municipality, or is that not even close to correct? I'm sorry. You're going to go to the planning board if we turn it down.
Can I?
And they
Actually,
could
Michael,
approve it.
Can I speak
Actually,
to that
Michael, I
quickly?
don't think they can do that, and here's why.
It's a D3.
Yes, that's why they cannot, because they can't meet a condition of a nursing home that's in the OR zoning code. They can't meet that. They can't get a nursing home license. They're not a nursing home.
Can they
And-
ask for a variance? Are you
Not
saying-
from the planning board. They can ask for a variance from this board,
Okay,
but not from the planning board.
then it would be here, but it's not over tonight if it's, no, you just come in and ask for a variance.
No, it's not over. And my understanding, and Mr. Lario, you correct me if I'm wrong, but my understanding is in your noticing, you actually asked, as the catch-all phrase is, for any variances or waivers that the board deems appropriate.
That is correct. Yes.
So I'm gonna think that the applicant would say, having heard their testimony tonight, because as I understand it, they have the facility operator, they have a doctor, they have an engineer, and they have a planner who are going to try and address tonight the concerns that were raised in Mr. Bridger's memo. So tonight, if the board was persuaded, they could grant the variance at this application. I mean, that's possible, but they can't go to the planning board.
Okay,
That's not an
yeah, I
option for them.
stand corrected.
They
but-
can't go there.
So Karen, are you saying that this could be a full-blown hearing tonight? Or are we just supporting or rejecting Mr. Bridges' interpretation of what the documents say?
The only reason that I'm raising the possibility that it could be a full-blown hearing tonight is because, as I understand it, they have a team of witnesses to testify tonight. I assume to address questions the board may have, the zoning officer has. We have other staff here at our meeting, so that if they were to present all this, then the board asks them to file an application now, change the application, say, well, we want a variance now from the conditional use standards. They're just going to represent all that testimony. They are here tonight. They have all their witnesses. If they didn't have witnesses with them tonight and all they said was, look, we have an argument, we think the zoning officer is wrong, but they've gone beyond that. They have brought their witnesses and have said, well, we're ready to present testimony. We'll present our case to you tonight. So the only reason I'm raising it is that, having done that, if they're told, no, come back, change the name of this application and bring it back to us, I don't know what other testimony they'd present. So this is why I'm raising that question, that's all. Because it normally the board, does not get appeals of the zoning officer's denial of a permit, but there's certainly, the MLU allows for that, and an applicant is allowed to do it. So I'm simply raising it as a consideration tonight because they have all their witnesses and they are ready to present testimony. Now I see our planning director is raising his hand and I've got to swear him in. Mr. Les, could you swear or affirm any testimony you give this evening will be truthful? Steve, is that okay if we have Mr. Lesko
Certainly.
comment? Okay.
Yes.
Thank you, Chairman, and good evening, members of the board and members of the public. I just want to note, though, for the context of that conversation, we as staff outside of Mr. Bridger have not written any reports on this application. If this was an application that we would normally have a traffic engineer or another professional contribute a report to, we have not done so. So just want the board to be aware of that. We've reviewed the application and that's why we're here, and we could speak to the appeal that's occurring at this time. But in terms of a full application, full variance hearing, we're not as prepared as we normally are. We have not done those reports that you're accustomed to.
And I think also, and I won't take it too much further, even something like inherently beneficial, there's arguments against that depending on proven market needs or not needs. There are measures related to that. You can't just, you can just assert that it's inherently beneficial and the town needs the drug and rehab, but technically you should have to prove it. And we should be prepared, if they're going that way, to say yes or no in agreement with that. And I don't know that we're prepared for that. That's a whole nother type of hearing than just, yes to Derek or no to Derek's opinion.
Yeah, I had one other question. Sorry.
Go ahead, please.
For an appeal of a zoning officer's determination, is there the same noticing for neighbors as there is for a variance?
Yes.
There is the same noticing. Okay.
And they did.
Okay.
They did notice.
Any other questions at this point? Or should we allow the applicant to go further with their presentation, which I think should? Okay. Proceed.
Thank you, Mr. Chairman. I'd like to start with our project engineer. Olivia, there you are. So, Olivia, you've been sworn in. If you could you please provide your qualifications to the board?
Yes, absolutely. My name is Olivia Kononiuk, spelled Kononiuk. I'm a project engineer at Stonefield Engineering, located at 15 Spring Street in Princeton, New Jersey.
Okay, and your education?
I graduated from Rowan University with a bachelor's in civil engineering, and I'm a professionally licensed engineer in the state of New Jersey with a license in good standing.
And you've appeared before land use boards, planning, zoning boards like this previously?
I have.
Okay, Mr. Chairman.
We'll accept the engineer as an expert.
Thank you very much.
Thank you very much.
Let's start with the site in question first. In anticipation of this meeting this evening, you prepared and reviewed the site survey for this subject site, correct?
That is correct.
And you reviewed the prior approvals from 1999?
Yes.
Okay. And you're familiar with the site in question, the prior approvals, that was all reviewed prior to tonight's meeting?
Yes, I have. I've personally visited the site and have gone over the local zoning ordinance and the letter from the zoning officer as well.
Okay, so let's start with if you have an aerial of the site.
Yes, and I'm going to share my screen. Okay. Can everybody see my screen?
Hilario, do you want the, oh, you already have a date exhibit A. Okay, thank you.
Yes, I marked it exhibit A1.
Okay.
That's good with the board.
Okay, so utilizing A1, can you explain the existing surrounding sites and the site conditions themselves?
Yes, absolutely. So this property is located at first at 728 Bun Drive. The subject site is a 6.27 acre lot within the Office Research District. Site's pretty secluded, with the existing building being tucked in over 200 feet into the property and screened well with mature trees and robust natural vegetation. Existing on the site today is the 67,000 3-story building, which previously operated as a nursing home. Access to the site is provided via one full movement driveway along Bun Drive. And also on the site is 60 parking spaces, a stormwater detention basin, as well as lighting infrastructure and landscaping.
Okay, and just to confirm, we are not proposing any changes to those site improvements that you just mentioned, correct?
That is correct.
Okay, for the ingress and egress to the site, you've reviewed it, and in your opinion as a professional engineer, it allows for safe and efficient ingress and egress from the subject site, correct?
That is correct.
Okay. You mentioned the 60 existing parking spaces. Can you speak a little bit as to the parking approvals as part of that 1999 planning board approval?
Yes, so 60 parking spaces are on site, and 20 parking spaces were approved as a bank parking spaces to allow, for additional parking should it be required based on the use and the demand of the use in the future. So currently there's 60 parking spaces on site.
Okay. Have you reviewed the parking demands associated with this proposed use against the ordinance to determine the adequacy of existing parking?
Yes, I have. So, while there's no specific requirement for the drug and alcohol rehab use, the closest similar use would be a convalescent care facility, which has the same requirements as a nursing home. This is related to people recovering from illnesses or surgery. The idea that it's a rehab is likely provides more of a close comparison to our facility. And per the Princeton and New Jersey Code for nursing homes, the parking calculation require approximately a total of 75 spaces for the total 148 beds. And this would be if the facility was running at full capacity.
And that includes a number of spaces required for the patients themselves as well, correct?
Yes, this is including the 148 beds.
Okay. So with the 60 existing and 20 bank parking spaces, there are enough existing spaces to cover the parking demands associated with this use, correct?
That is correct.
Okay. And you're not anticipating any increase on trip generation, given the similarities with the prior nursing home use and the rehabilitation use, correct?
No trip generation changes.
And that's based upon, again, the number of individuals who will be residing within this facility and the number of staff. Given the similarities between those two numbers, the traffic demands anticipated are the same.
That is correct.
Okay, so let's talk about site infrastructure. You mentioned some of the site improvements, stormwater basin. Can you discuss a little bit as to what other site improvements are out there now, lighting, landscaping, et cetera?
Yes, absolutely. So we've got the building part. We've got the building, the parking lot, surrounding site features, including landscaping, lighting, utilities, and any stormwater infrastructure on the site. The building and parking lot are in good condition. They just need a little bit of cleanup. There's no evidence of severe ponding or flooding on site. And I visited this site this week after all the heavy rain that we've had and has observed a dry stormwater basin. So this indicates that the basin is functioning as designed, even with minimal maintenance since the facility closed. And the applicant will intend to maintain the basin, parking areas, and landscaping as per the previously approved plans from 1999. Some landscaping on site is dead or dying due to the local deer population helping itself to dinner, but with regular site activity and continued landscaping, dying plants will no longer be an issue once replaced. And the lighting has been constructed as approved and plans to operate as such. Overall, the site and the building is suited for the proposed use.
So just to confirm, because what we are proposing is a continuation of that nursing home use, all of the landscaping requirements that were conditions of that prior 1999 approval will have an obligation to adhere to all of those. Essentially, all the conditions within that prior resolution will have an obligation to adhere to all of those, correct?
Yes, that is correct.
Okay. Essentially, this site is going to continue to operate identically to its prior use, identically to how it was previously approved to operate, correct?
Correct.
Would you agree that there's no intensification triggers here associated with the proposed rehabilitation use?
Yes, I would agree.
And it's fully compliant with the OR1 standards, the conditions and standards contained in the prior 1999 approval and the previous approval from an engineering standpoint?
Yes, that is correct.
Okay, and if you could, just briefly, I believe you have a site survey that was prepared. If you could pull
Yes.
that up as well.
So this was previously submitted. Can you guys see this as well now?
Yes.
So this was previously submitted. I'm not sure if the board would like me to mark this as A2.
If you could, please.
That is quite small. This is the Alta survey prepared by my office as well, dated January 31st, 2025. With the north to the top of the page, you can see the building in the center of the page, followed by surrounded by all of the site improvements.
And again, just to confirm for the record, no changes are proposed as part of this proposal with any existing improvements on site.
That is correct. There are no site changes proposed.
Okay. Mr. Chairman, those are all the questions I have for the project engineer.
I have a question. I'm sorry, I can't pronounce your name. I don't
Oh,
want-
good.
Okay.
Kanoniuk. Yeah, it's Polish.
Okay, it's all right. You were testifying as to traffic and trip generation. Are you a traffic engineer as well as a civil engineer?
I am not. Based on the use, there would be no change per the ITE, but we would of course prepare, the parking study and anything that the board would require to be reviewed should this application, the determination be approved.
Well, I mean, it may be necessary to do that prior to the application being approved. If you're, you know, I'm just trying to make
Yeah.
sure that
Yes.
the witnesses are testifying to all aspects of the project, and I just want to make sure that, you know, we're dealing with experts in their particular expertise.
And if I can, Mr. Chairman, I think ultimately your point gets to really the heart of the appeal here is it is the position of the applicant that what we are proposing is a continuation of the previously approved use, that it is not a new use of the site. And because of that, the traffic demands anticipated for this site, the parking demands will be substantially similar to the point that new traffic reports and parking adequacy reports are not required because this is a continuation of what has been previously approved.
So,
Okay. All right. I'm okay. I mean, let's continue on, but I am concerned that we have adequate traffic testimony. Okay. Let's keep going.
Mr. Lario, will someone, I didn't understand with the backgrounds of the witnesses that were presented, that somebody would be explaining sort of the first point in Mr. Bridger's interpretation about the use being essentially the same. A nursing home and rehabilitation center's use being essentially the same as a proposed drug and alcohol rehabilitation center. It seems to me we're talking about peripheral issues. The parking won't be all that different. The traffic won't be all that different. Will someone be speaking to the actual use? Or is that not going to be presented tonight? Because it seems to me that's the crux of the issue. And before we go into, you know,
Sure.
air rights and riparian water and whatever else we want to discuss,
Sure.
seems like that's a fundamental thing that we need to address.
I agree with you, Harlan. I think that should be the first order here.
Yeah.
What we will be able to provide on the record is operational testimony as to what is being proposed here. Additionally, we'll have our planner indicate that under existing New Jersey case law and your ordinance, these two uses are functionally equivalent, that there is no difference between a nursing home use or a rehabilitation use. Now, obviously, there is the license citation question, which we will address, but I think what was said at the beginning of this meeting as to, well, what if another nursing home wanted to use this? And it was said, well, they likely wouldn't be before this board. It's our position that that is what is going on here, that another nursing home is essentially looking to operate this site just because New Jersey law has consistently found hospitals, nursing homes, and rehabilitation facilities to be identical uses from a zoning perspective.
Can I ask a question, please?
Sure.
From your engineer, Mr.
Yeah.
Lario? Could she break down the parking in the context of the ordinance where 0.03 spaces per bed, maximum number of employees per shift, and then a multiplier? So we can take that in that context, please.
Sure. So with the 148 beds, one parking space for every 3 beds, approximately 49 spaces. Then assuming 1 staff member per 8 beds, that would be 18.5 spaces, so 19 spaces. Altogether 68 with the 10% multiplier brings us to 75 spaces.
Thank you.
And again, while we do meet that requirement with the existing and banked parking, I do think it's important to note for the record, 49 spaces are being reserved for the individuals who will reside within this facility, and none of the individuals will have access to a vehicle while they're here. So it is fully our anticipation that this site will be overparked in the same way that the nursing home site was overparked and that additional banked parking spaces were never required to be constructed.
There were issues with the nursing home parking because they asked me about how they could get additional spaces. So just put that on the record.
Okay, well, again, I think the critical point here is this has been reviewed against the parking ordinance, which states the requirements for this type of use. And we meet the requirements with the number of parking spaces previously approved.
Okay.
Mr. Chairman, before we move on from that, would you mind if I ask a few questions?
Certainly, please do.
Thank you, because I just want to dig deeper on that. So we've heard that it's identical to the prior use. Do you have the numbers of what was approved previously with that use and what is being prepared now? I know I just caught the 75 parking space, but I'm trying to look through my notes now. Is that what was testified to in 1999? And is that what was ultimately put on the site there?
It was 80 parking spaces, what was approved in 1999. 60 to be constructed, 20 banked parking spaces.
Okay, and that was based on the number of beds, which you're now, that number's changing, correct, with this new application?
It is based on the number of beds and the number of employees, correct?
Yes, okay, got it. Okay, thank you.
Any other questions, board members right now? Okay, please continue.
Thank you, Mr. Chairman. I'd next like to call Dr. Allison Tarlow. Dr. Tarlow,
Hi, good evening.
if you could you please introduce yourself to the board and provide your qualifications?
Yes, hello, good evening, everybody. My name is Dr. Allison Tarlow. I am a licensed clinical psychologist, and I am licensed in the states of Florida, New Jersey, Pennsylvania, Indiana, and Massachusetts. I have been licensed since 2002. I am also a Florida Supreme Court certified family mediator and parent coordinator. And I also hold a certificate in addiction professional and also international certificate for drug and alcohol counseling. And also I have a certificate in recovery residence administration. I have been working for substance abuse treatment facilities since about 2008. And I am currently the Chief Clinical Officer for Boca Recovery Center, which is a multi-state substance use disorder treatment facility providing substance use disorder and co-occurring mental health treatment. Boca Recovery Center opened a facility in New Jersey, in South Jersey, Galloway in 2021. And we've been open in Florida since 2016, and we continue to operate and grow successfully. We are a for-profit facility, and we are in the business of helping people to recover from substance use disorders and co-occurring mental health treatment.
Mr. Chairman, I offer
Nice to meet you all.
Tarlow as an expert in substance abuse treatment.
Yes.
I will accept that. Please
Thank
continue.
So let's start with the proposed facility. You indicated that you are currently employed by Boca. Boca will be the operator of the proposed site, correct?
Correct, yes.
Okay, can you provide a little bit of information as to what is being proposed here, what a licensed non-hospital based subacute detox and residential short-term rehab facility is?
Yes, absolutely. So we are a freestanding non-hospital facility, and we provide treatment and care, both medically and clinically, to individuals who are seeking recovery from drug or alcohol addiction and co-occurring mental health issues. And what that looks like is two different levels of care. The first level being what we call subacute medical detox, where an individual will come in and they will stay with us for anywhere between 3 to 10 days for that medical detox process. But I would like to say on average, they will be at that level of care for about 8 days, at which point in time, the individuals will then step down within our facility to a short-term residential level of care, where they are then able to focus more on their clinical treatment planning, and we're helping them establish, in addition to the treatment planning goals, their aftercare, so that when they are completed treatment with us, they will generally go on to another lower level of care somewhere else for continued treatment, or they may return home, you know, based on the needs of the patient and also the recommendations of the staff.
Okay, what's the average length of a patient stay?
So an average length of stay is approximately about 22 days. And again, there are some individuals that will stay up to between 28 and 30 days, and some who will be in and out within about 10 days. But I would say in general, approximately 21 to 22 days is the average length of stay.
Okay. And there is a process for patient intake and discharge, correct?
Absolutely. The individuals are go through a screening process. Initially, we do medical and clinical pre-admission screening to ensure that this is an individual that can benefit from the type of treatment and care that we are providing, and that they meet criteria per governing bodies, for example, the Joint Commission and the state of New Jersey, for that level of care. And then they will be brought into our facility where they will be provided with a pretty in-depth intake process. As you stated earlier, Michael, the individuals do not come with vehicles, so the patients do not have vehicles that they park at our facility. And so also when they are staying with us in our care, we typically do not have visitors coming in and out because they are with us for a brief amount of time. Any visitation that does take place typically will be over Zoom or virtual sessions where there is a professional present as well.
Okay, and those individuals, they will reside full-time in the facility while receiving treatment, correct?
Correct. They will reside in our care, and they do not leave our care unless there is a medical emergency, and that they, for some reason, needed to, for example, visit a dentist because they had terrible toothache and we were not able to provide the dental care for them. And then at that point, they are brought by our staff to that, for example, dental office where they would get that treatment and then come back into our care.
Okay. And all patients, while they're within the facility, are being monitored 24/7 by a healthcare professional. Is that correct?
Correct. One of the criteria for the subacute medical detox and the short-term residential level of care is that we do provide 24-hour clinical and medical supervision, which includes registered nurses. We have medical doctors and nurse practitioners, specifically psychiatric and family nurse practitioners on site every day. And we also have what we call behavioral health technician staff that are also at the facility 24 hours a day. So there is always staff at the facility, qualified staff at the facility.
So that 24/7 monitoring requirement, that is something that is required by the state of New Jersey and the Department of Health in order for you to obtain and keep your license.
Correct, correct. And the state of New Jersey has pretty stringent requirements as far as that's concerned. So, for example, several nurses per X number of clients, which I can give you that information if it's needed. But because of that, we know pretty specifically what we are required to have, and we, as a general rule and per our own policy and procedure, go above that in order to provide just a higher quality of care.
Okay, well, let's talk about the staffing plan. You mentioned the employees that are required. Can you speak a little bit as to what the staffing demands are for this type of facility?
Yes, absolutely. So in the state of New Jersey specifically, the clinical therapy staff is required to have one therapist per every 8 patients on their caseload. We are required to have a nursing ratio of 1 RN to every 22 patients. For a case manager who's responsible for helping the client with any needs they may have that don't involve treatment, but involve paying bills or housing or things of that nature, like sort of day-to-day life functioning. We require 1 for every 25 patients. We anticipate having 5 housekeepers, but not all there at one time. So they're rotating to about 2 housekeepers that would be there at any one time. And then we have some administrative staff with 148 beds. If it were to be filled to capacity of 148, which in my experience doesn't usually happen. Typically you run at 80% capacity usually in these facilities. We would be looking at having approximately 36 members of staff in the building at any one time. We also have nurses who are there for 12-hour shifts. So for example, 7 a.m. to 7 p.m. and then 7 p.m. to 7 a.m. So there is a staff changeover at that time. And then we have the clinicians who will come in typically anywhere between 8 and 9 and work for, you know, an 8 or 9 hour day. And then we have the behavioral health techs that will also work on shifts, first, second, and third. So we have some people coming and going, but it is not everybody coming and going at once.
Okay. Now, in connection with this use, you've reviewed the floor plan of the prior nursing home use and the anticipated floor plan for your use, correct?
Yes, I have.
And the nursing home layout, the proposed residential facility layout that's required, that they're very similar. Is that correct?
That is correct. In fact, so similar that in other facilities, we have been able to take a nursing home that was previously used for the nursing home purpose, and we have been able to put a substance use disorder treatment facility there because it is so well fitting for our needs.
And that's largely driven by the requirements provided by the Department of Health for these types of uses as to hallways, room sizes, access, kitchen facilities, et cetera. How this was designed was consistent both with the nursing home and with the proposed rehabilitation facility, correct?
Yes, that's correct.
And it allows for continuity in care and use for this proposed use, correct?
That's correct.
Okay, so let's focus in on the licensing requirements for this use. Can you speak?
Can I ask a question? One quick question.
Sure.
The behavioral health techs that you mentioned, do they provide security for the residents? Who provides security? Which in your staffing that you talked about, who provides security?
Security from what?
Security, if again, and I'm not an expert in this, but if a patient in the recovery process is acting out, who provides assistance?
Anybody who is staffed and in the building would be able to provide assistance, including behavioral health techs, all the way to licensed clinicians and registered nurses. And we also have LPNs in the building as well. But anybody who is working there has to be onboarded and has to come with qualifications in order to be able to work with that population.
I have a question. Will the residents be able to leave of their own free will into the neighborhood?
We are not a locked facility. So the residents that come there are 18 years old and up, and they come there of their own choice. And so therefore they come of their own free will. And if they choose to leave the treatment facility, we are not a locked facility. However, we have protocols in place in which we are working with the individual and oftentimes family members and other, staff who are working in the facility to help them with their decision-making processes, because it's in everybody's best interests for the individual to complete treatment and transition to a lower level of care. So in general, there are not people trying to escape, like, I don't even know what people would try to escape from these days, I guess prison, but people are typically not trying to escape. They are there of their own free will.
And I was just going to say, the reason for that is they've made the determination to seek the medical treatment through the rehabilitation facility. They're there to get better. So in your experience, you don't find a situation where people are frequently leaving the facility because they're there because they chose to be there.
Correct. And they are not coming to us because they've been court ordered. They are adults, so they are making a decision to come there of their own free will.
But while they're receiving treatment, they are not authorized to come and go as they please, correct?
Correct. They understand that in part of the rules, they remain in our care, in our building, and they do not leave the facility unless, as I said, there was a medical need for them, in which case they are supervised and taken wherever they need to go.
I understood you to say that typically they're not court ordered. What is atypical?
Atypical is that a parent may get guardianship of their child if their adult child was not capable of making sound decisions as a result of their substance use disorder. And so on occasion, not very often, we may have somebody who has a family member who has guardianship over that individual. So they would be involved in signing consents and things of that nature. But that doesn't happen very often. In fact, I don't know that we've ever had that situation occur in New Jersey.
Okay, just to follow up a little bit, if someone checks themselves in either by themselves or through their guardian, and they decide they want to leave before the treatment is complete, what happens?
We meet with the individual, we find out what their barriers are to remaining in treatment and completing. And in the event that they are not able to make an appropriate decision to complete treatment, we then help to facilitate them either transitioning back home or to their families or loved ones or to another facility that better meets their needs. There are occasions where individuals decide they want to be, in a different area or closer to home, or, there are different factors that can come into play. And we work with the case management team to facilitate a transfer or transition to that next facility or back home.
So what would happen if you considered in the state that they're in that they pose some sort of danger to the community?
Then we would be contacting the night emergency services, just the same as we would in an outpatient level of care if somebody presented as a harm to themselves or others.
Okay, thank you.
Dr. Tarlow, is that something you experience frequently?
No. We do a heavy screening process on the front end because we are looking to intake individuals that are going to need our services and benefit from our services. And, in this day and age with medical insurance providers, there are very stringent requirements as to who can be placed at certain levels of care. And the goal is always to place the patient at the least restrictive level of care. But what we're providing with the subacute medical detox facility is a way for these individuals to get significant medical relief from that from detoxing from alcohol, for example, or benzos, for example, benzodiazepines that are can be risky to their health and also incredibly physically uncomfortable without that medical detox protocol in place.
Dr. Tarlow, sorry, Michael?
Yeah, quick question. I don't have in my notes, but I know you have housekeepers, 5, 2 at any time might be there. Is there kitchen staff? How is food handled?
Yes, we usually we will have 2 chefs that work in the kitchen, but they are, they work different schedules. So they are there at some points together, but they are also, covering for breakfast, lunch, and dinner. But we do have 2 chefs on staff at any one time.
And they would utilize the existing kitchen facilities within the site, correct?
Correct.
And is anything regarding your staffing written down and submitted to us? I haven't seen anything, but
Well, I haven't written anything down and submitted it, but I have a feeling that that's something that we could provide to you because we do have protocols and policies and procedures in place that have been approved by the Department of Health, the governing bodies, joint commissions, the state of New Jersey in the instance of our facility in Galloway, in order to meet the requirements that the state has for these types of facilities.
So it's driven not by your demands or your determinations as to staffing requirements. The state essentially drives what is the employee requirements for these types of uses.
Correct.
Okay, thank you.
Dr. Tarlow, on that question of staffing, could you tell us what the staffing levels were at the Princeton Care Center, the former use of the building?
No, I can't.
Okay, so you're not aware if they're the same as what you're proposing, even just in raw numbers even?
I've never worked in a nursing home facility, so I cannot speak to that.
Okay, understood. And then just going back to a previous thread with a similar question that I don't want to put words in your mouth, but I imagine we might get a similar answer. Are you aware of if the Princeton Care Center, the former use, had a similar policy where a resident could leave?
I'm not aware of any policy that the Princeton nursing home facility would have, but based on my knowledge of nursing homes, I would imagine they don't want their patients loosely wandering around.
Certainly not down
And in fact,
Bun Drive either.
one could argue that, believe it or not, the individuals who are coming in for substance use disorder and co-occurring mental health treatment, and we're talking about depression and anxiety. We're not talking about serious mental illness. We're talking about, you know, depression and anxiety and things of that nature. But one could argue that they would be of a more sound mind than perhaps people who are going into a nursing facility. You know, again, from dealing with my own relatives who've been in nursing facilities, I know that, you know, the cognitive impairment typically at a nursing facility will be higher than something that we are dealing with.
That's a conversation I'm not qualified to get into. I'm just trying to understand if the uses are the same. But thank you.
Absolutely.
I think
Just to follow up, I think with one of those questions as to staffing demand, you've obviously reviewed the layout, the nursing stations, the doctor's offices of the prior nursing home. And have you found those employee staff areas to be consistent with the demands of what you are requiring for a residential facility?
Absolutely, yes.
Okay, and again, those demands are the requirements are all promulgated by the state through the licensing requirement as to how many staff members the nursing home facility would require.
Correct, yes.
Okay, thank you. So I think, unless there's any other questions, I think that's a good segue into the licensing requirements specifically. If you could you speak a little bit as to the specific license that is required for this type of use and under whose supervision it is issued by?
Yes, so we operate under the, I believe it's the Office of the Attorney General in the state of New Jersey, and the Department of Health. And so our license is what we call subacute medical detox, and that is also considered by the American Society of Addiction Medicine to be what they call level 3.7, which again provides for certain number of hours of treatment and services that need to be provided. For example, meeting with the physician at that level on a daily basis. So there's a higher level of medical monitoring in that first subacute medical detox level of care, which is again ASAM 3.7. And then the other license would be the short-term residential license, which allows for us to continue with that medical supervision. The patients at that point don't need as much medical supervision, but they still do require to be monitored medically. And then at that point also they're having upwards of 25 to 30 hours of psychotherapy services also provided to them at that short-term residential level of care that is required by the license.
Okay, and there's inspection requirements, oversights in connection with the license. Can you speak a little bit to those?
Yes, so we have to develop very detailed policies and procedures that are submitted for us to then be eligible for licensure. And then we have, upon opening, we have an initial, what we call an audit, where the department will come out and review the facilities and look at the staffing and look at our human resource records, and to ensure that we are qualified to be doing what we're supposed to be doing and that we're doing it correctly. And then again, typically the licensing is up for renewal. I want to say it's every 2 years. It could be in New Jersey that it's every year, but I believe it's every 2 years. And actually with Joint Commission also, they do every 3 years, but annually they also have like a sort of mini review or audit of care as well.
Okay. Again, just for the record, the license that is being issued for the Department of Health for the residential facility, the rehabilitation facility, it's authorized under the Healthcare Facilities Planning Act. Notably, again, just for the record, that is the same authority that authorizes the issuance of the license for the nursing home uses. Dr. Tarlow, is that correct?
Yes, that's correct.
Okay. Mr. Chairman, I have no further questions for Dr. Tarlow.
Board members, any questions for Dr. Tarlow? Okay, please proceed.
Next, I'd like to move on to
Chair.
Yes.
Sorry, I just had one more question before we move on from Dr. Tarlow.
Sure.
Just one last question. Are, based on those licensing requirements, going back to the staffing, are the staffing levels the same under the subacute non-hospital based residential license as they are under the nursing home license under NJAC 839?
I don't know what the specifics are for a nursing home as far as the staffing requirements. I am only well versed in the staffing requirements for substance use disorder and co-occurring mental health treatment.
Okay, understood. Does anyone on your team, Mr. Lario, know of that information?
So again, I think the answer to that question is that the employee areas within the existing facility are consistent with what is required for our use. So while we don't have an exact number, I don't think an exact number is ultimately going to allow this to be the same or similar use. I mean, they require a certain level of staffing to allow these uses to take place. There are employee areas within the existing facility which are similar to what we will require for this use. Could there be a slight difference between the total number of employees? Yes, but I think ultimately, under your ordinance, if there is a difference as to the employees, we still meet the parking requirement. So from an intensity standpoint, any change within the number of employees required, it's not going to impact the intensity of the use in any way.
Without having gotten that information in a traffic study, how is the board or us as professionals, how are we supposed to determine that?
Because it's the same use that the board previously reviewed and approved. That's our position, that the law requires this board to review the nursing home use and the rehabilitation facility use as the same.
Can I ask a question? I don't want to be too focused on the parking, but I'm just curious. The patients are there of their own free will, so they're adults checking into the facility. How does it typically work? Is it somebody is always dropping off the patient? If there's no, I understand they're not using cars while they're there, but are there some percentage of patients that drive themselves there and the car is there for the duration of their stay? How does that factor in? Are they always dropped by somebody?
What at the pre-admission, when we're screening and we're setting them up for admission, we're setting all of that up, and so either they are dropped off by a loved one, or we have vehicles that we would bring to go pick them up, and we bring them in.
Okay.
I just wanted to ask for clarification on parking. I don't know if anybody else has the same question. But Derek, your memo says, and I see that in the resolution from 1999, 47 parking spaces and 20 banked. But so is this where we're getting the number of 60 spaces?
No, there's 60 spaces and 20 banked. That's incorrect.
And when did it go up to 60? Because the resolution talks about 47.
The resolution, I think, speaks of 47 in reference to the limitation on 30 spaces in a parking lot.
Okay.
I think that was
a variance was granted for that.
Yes.
Yeah.
Okay, thank you.
But I had a question. I thought Dr. Tarlow said that at one point there were 36 staff members on.
At any one time, if we had 148 beds, but we had approximately 120 of those beds filled, we could anticipate having 36 staff in the building.
Because that seemed to be different than what the traffic engineer said. I thought she said 18 to 19 parking spaces.
If I can, I think that's what's required under your ordinance.
I'm just saying it just seems to be a different, what's required on our ordinance is the maximum number of employees per shift, which I'm trying to get a number on that. Is that 18 or 19 or is it 36? So if it's 36, then we're at 86 plus the multiplier for the visitors would put you past what's on site.
If Mr. Chairman, if it's easier, I can certainly go back to our engineer to answer that question. I think that's a more appropriate person to answer.
I think it's a staffing question. I mean, it's the engineer can do the math. Anybody can. 0.03 times 148 beds plus employees plus a multiplier. So that's what, when I heard 36 staff members from Dr. Tarlow, just kind of triggered my thought process. This is just the whole thing and not having anything to really review.
Yeah.
And that's truly, Mr. Bridges' question is an operational question, not a civil engineering question.
Well, ultimately, I think the question is the parking demands under the ordinance and what the ordinance requires for the site. And I think my understanding is that we are compliant with the ordinance requirements based upon the calculations provided. The variance relief is not required.
I'm asking, Dr. Tarlow said 36 staff members. It seemed to be on staff at one time. So if you take 148 times 0.3, you're at like 49. You add 36, you're at 77. And if you add the multiplier, you're over the 80. So I'm just trying to get an idea, because there was a parking issue there before. And granted, under your view, it's the same use, but you know, it could be an issue. I'm just trying to iron that out.
I understand the concern that's being raised, but ultimately, given the number of parking spaces on site, given the fact that these residents will not have vehicles there, we believe that the parking is more than adequate to meet the demand anticipated.
Do you think it's a variance?
I do not know, because it's a continuation of the use.
But any use would have to deal with the parking. If somebody came in and said they had more spaces, we'd want to know. And obviously, it's a maximum number they're looking for, not a minimum, because they don't want too much parking on site. But you know, it was a case before, for whatever reason, the previous nursing home never built the 20 bank spaces. I don't know if it was financial, but that's just, there seems to be a discrepancy between the engineers, staffing, and I would rely more, I think, on the operational guidance of Dr. Tarlow in that situation. So
What I can do is I can certainly speak to the applicant. I know this setting makes it a little difficult to have that conversation as to the employee requirements, but I understand the question that's being asked, and I certainly think that's something that I can try to get some more clarification from the applicant on.
Thank you.
Yeah. Any other questions at this point? Okay, please continue.
Thank you, Mr. Chairman. So next we have our planner, Mr. Andrew Janow. Andrew?
Yes, good evening.
If you could, before we begin, could you provide your qualifications to the board, please?
Certainly. My name is Andrew Janow. I've been a principal in the firm of Beacon Planning and Consulting Services for the last 27 years, founder of that firm. I'm a licensed professional planner in the state of New Jersey, as well as a member of the American Institute of Certified Planners. I'm currently serving as the planner for the borough of Freehold in Monmouth County, the borough of Carteret in Middlesex County, Livingston Township in Essex County, and redevelopment planner for the city of Bayonne and the city of South Amplewood. I've testified throughout the state of New Jersey, been qualified as an expert in land use by the Superior Court of New Jersey, and in 2022, Governor Murphy appointed me to the State Board of Professional Planners.
Accept you as an expert in the field.
Thank you.
Thank you, Mr. Chairman. Mr. Janow, in anticipation of this meeting, could you please explain to the board what you reviewed?
Certainly. I'm sure the board has a copy of the report that I have prepared dated February 11th, 2025. In preparation for that, as well as for this evening, I've been to the site several times. I reviewed the prior approvals, the survey of the property, the correspondence related to this property, as well as Mr. Bridges' memorandums dated June 5th and June 6th. And I certainly have an opinion with respect to those conclusions and to the conclusions within my report. In summary, Mr. Bridges essentially concedes that there are two issues that he has concern related to regarding this application or the use of this facility as a drug treatment and rehabilitation facility. And one is related to parking, which you've heard testimony about, and I understand there's some issues that we'll be addressing further on that. And the second is the nature of the licensure. The nature of the licensure, while you are very specific in terms of a license citation within your ordinance, is remarkably similar and under the same jurisdiction of the New Jersey Department of Health. The facility would be administered by the Department of Health and would have the same oversight essentially as a nursing home under the same agency. So there is a specific case law that I cite within my report on page 6. And as Mr. Lesko, I'm sure, is familiar with the Cox Treatise, which goes through land use, there is a citation that's very much on point in section 32-5.2. Under the inherently beneficial uses, there are 3 legal citations that kind of walk us through how a hospital, a nursing home, and a treatment facility are, from a zoning perspective, identical. And if anybody wants to kind of follow along, that's on page 6 of my report. And it starts with hospitals or uses that have been found to be inherently beneficial and promote the public good. Kunzler v. Hoffman permitted a private hospital for emotionally disturbed people in a residential use, citing it as an inherently beneficial use. Medical Center v. Princeton Township basically concluded that hospitals are indisputably inherently beneficial uses, and that hospitals have been confirmed as such by the legislation through NJS 4055 DF4, which was adopted in 2009. It has also been held pursuant to Serbo v. Orange Board of Adjustment, which is a 1972 case, that residential narcotic rehabilitation and treatment centers under the supervision of the Commissioner of Health, and this facility was a hospital and qualified as an institutional use under local zoning. And then finally, it was held that nursing homes and hospitals are uses that are so similar physically and functionally that their disparate classification for zoning purposes cannot be justified. And that was Urban Farms v. Franklin Lakes, a 1981 appellate division case. So as you can see, Cox kind of walks us through not only the fact that these uses are universally beneficial to the public good, but that from a zoning perspective, hospitals, nursing homes, and residential narcotic rehabilitation and treatment centers are identical pursuant to zoning. Furthermore, in Mr. Bridges' letter, he cites that your code does not specifically define a drug and alcohol rehabilitation facility, and as such, your ordinance doesn't specifically permit them anywhere within the community. You do define nursing homes, you do define assisted living, you also define hospitals, but the definition of a treatment facility is absent. And once again, we rely on that treatise and that walkthrough of the various case law that leads us to the conclusion that hospitals, nursing homes, and residential narcotic rehabilitation and treatment centers under the supervision of the Department of Health are equivalent from a zoning perspective.
Why is that important that a definition for a residential treatment facility like this is not included in the ordinance?
Well, essentially, it's an omission in your ordinance, and you'd have to look at what are essentially equivalent uses. And we have case law that determines that nursing homes are an equivalent of that use and should be treated the same. Essentially, the only distinction in classification is the nature of the people seeking treatment at that facility. And if you distinguish and prohibit treatment of people with such disabilities, you're essentially discriminating against the people.
Okay. So, and again, I know you mentioned those case laws, they obviously disfavor distinctions between these uses, and they've consistently overturned board determinations.
They've been overturned and they've been determined to be zoning equivalents.
Because trying to make zoning distinctions on these two uses is something that, again, the courts have continuously rejected. Obviously, from a licensing standpoint, the licenses may be slightly different for a rehabilitation hospital or nursing home use.
That's correct, but the nature of operations are identical.
From a zoning perspective.
From a zoning perspective.
Correct. Okay. So let's talk a little bit as to the specifics there, because I think in the ordinance, it talks about obviously the specific citation for a nursing home, but it talks about 24/7 care. Can you speak a little bit as to what's required under the ordinance and what's provided for with the proposed residential treatment use?
Sure. Let me walk through the ordinance and the conditional use standards. So those standards are contained within section T10B 272.40 within your ordinance, and that pertains to nursing homes and assisted living residences conditional use requirements. So requirement, and I'll go through these as they're listed in your ordinance. Requirement A is that a nursing home approvable as a conditional use must be a facility in a multifamily structure which is licensed by the Department of Health in accordance with NJAC 830 to provide healthcare under medical supervision and continuous nursing care for 24 or more consecutive hours to patients who do not require the degree of care and treatment which a hospital provides and who, because of their physical or mental condition, require nursing home level care. So what we're proposing is an in-residence treatment and recovery facility that will be licensed by the New Jersey Department of Health and will operate pursuant to the oversight of same. Care will be provided under medical supervision and continuous nursing care of these individuals for 24 or more consecutive hours to the class of patient as described having a disability related to a drug or alcohol addiction. Essentially, within that standard, the only distinction is the license statute that is being referred to. We are licensed under the Department of Health. It is a different license number, but for all intents and purposes, the patients that'll be at the facility that we are proposing will be receiving very similar care. There'll be the same classification as a nursing patient in terms of the type of care they require for 24 or more hours. They're not at the level where they require hospital care, but do need 24-hour supervision. So we are on point with that requirement. Under A1, your ordinance requires that nursing care beds are the approved beds in a nursing home which are available for patients. The rooms in a nursing home in which 1 or 2 nursing care may be located are designated as nursing care units. So we are proposing 74 care units. And within your definition of a care unit, a care unit can have 1 or 2 beds. Our facility will have 2 beds in each unit, 74 care units, 148 beds. And that is consistent with what your ordinance permits within this zone. The ordinance permits the lesser of, I believe it's 120 care units or 240 beds or 30 beds per acre. We are a little bit over 6 acres. I believe if we were to go to that letter of the law, we would be permitted up to 188 beds. We are 148 beds, and that's why Mr. Bridgers said that we are within the threshold of what your ordinance under the conditional standards permits for the number of beds. Point 2 within that citation reads, nursing home level care means care provided to individuals who have chronic medical conditions resulting in moderate to severe impairment in physical, behavioral, cognitive, or other psychosocial functioning. It includes, but is not limited to, partial and total assistance with activities in daily living, assistance with self-administering or administration of medications, the provision of treatments, and periodic reassessments as directed by the patient's plan of care. It also concludes that the provision of physiotherapy, occupational therapy, therapeutic counseling, and other rehabilitative services are indicated by the patient's medical condition. Again, care will be provided to the individuals who are suffering from a chronic medical condition. Addiction is defined as a chronic medical condition, and that it results in moderate to severe impairment and need of behavioral health care. They are going to provide that kind of health care at this facility. Curiously, the language within that section reads nursing home level care. And I thought that was curious because nursing home level care essentially you're defining as providing medical conditions to severe and moderate behavioral issues, cognitive issues, as the like. So the New Jersey courts have recognized that individuals addicted to drugs and alcohol meet the definition of a handicapped person requiring such care. And that's was adjudicated in the matter of Cahill 245 New Jersey Superior Court. That was a 1991 decision. The conclusion was reinforced by the Federal Americans with Disabilities Act and the Federal Fair Housing Act, which said that persons with handicaps are a protected class, and this includes persons that have alcohol and drug abuse issues. So they are a protected class of individual. They are deemed to be handicapped, and they do receive what you define as nursing level care at this facility. So again, we are on point, and thus far, in reading those 3 points of your ordinance, the only distinction is the specific citation of the Department of Health licensure that's required. And again, we are required to be licensed by the Department of Health. It is a different license citation, but it is still under the supervision of the same organization.
And the additional requirements within that section, nursing care for 24 or more consecutive hours, patients who do not require a degree of care and treatment which the hospital provides. We do meet all of that as well. It's just
It is absolutely on point with the type of care that's provided to the individuals that will be served by this facility.
okay.
And finally, 3 under that provision, a multifamily structure is a building containing 30 or more nursing care units, and each unit sharing with another unit or units 1 or more vertical or horizontal common walls, and each unit having its own separate entrance from an interior hallway or common area. Again, we are more than 30 care units. We will be 72 care units with, 74 care units with 148 beds. We meet that definition of a multifamily structure. That definition was applied to the nursing home, and it was testified that that nursing home is ideally suited, if not specifically suited to this use, because there are no improvements required to the exterior. The facility can function with the facility as it is situated today, and that there will be some minor modifications to the interior in order to increase the bed count and create bathrooms and the like, but that the facility is particularly suited to the use as it is essentially an equivalent level of care, provides for common kitchen, common areas, common eating facilities, very much on point. Section B within your ordinance on the conditional use standards are related to assisted living residences, so I'll skip over those. C is to qualify for a conditional use approval, the applicant must demonstrate that the nursing home or assisted living residence has received or will be eligible to receive a license from the state of New Jersey Department of Health pursuant to the provisions of the applicable state statutes and regulations. Well, Dr. Tarlow indicated to you the type of licensure that will be issued to this facility. This facility will be under the supervision of the Department of Health and will be eligible to receive licensure from that division for the operations at this facility. So again, but for the specific citation number of the license, it will be under the care of the Department of Health and will have license and oversight from that department. D, within your ordinance, is a single facility may include both nursing care units and assisted living units, to the extent that they are somewhat different quantitative regulations. In the subdivision for nursing homes and assisted living centers, the applicable number shall be computed by interpolation based on the number of nursing care units and number of assisted living units. So here, I mean, the ordinance indicates that there is some flexibility in terms of the type of care. This facility operated previously specifically as a nursing home facility under nursing home licensure. The care that will be administered in residence for behavioral health and rehabilitative care here will be specific, and it will be specific to substance and alcohol abuse dependency issues. It will not be kind of a hybrid issue, but it will be under the Department of Health Care. So I think we are on point with that. E, in its design of the site for a nursing home or assisted living residence, the applicant shall attempt to achieve the integration of the proposed nursing home or assisted living residence with existing and proposed land uses adjacent to the site. And here I'm going to cite the 1999 approval, which was on point with that condition. It read, the board finds that the applicant has attempted to achieve an integration of the nursing home with the surrounding area. This will be further enhanced by the landscaping to be installed. The testimony was that this use would be a good transitional use between the existing office uses to the north and east and the residential uses to the south and west. So that 1999 resolution acknowledged the efforts to integrate to the community, to integrate to the surroundings, and the success of that. And it warranted an approval from that board in 1999 based on that achievement. You then heard testimony from our engineer tonight that the operation will not alter the exterior. There will be some supplemental landscaping to replace some damaged landscaping, but that was the very landscaping that was cited in 1999 as appropriate in screening the facility from the neighbors. Section F is an informational section regarding conditional use under subdivision. Same with G and H. I is as part of this subdivision, the applicant must seeking approval for a nursing home shall submit a document describing its plans for helping people remain at the home or facility after they've exhausted their own financial resources. Again, that's something that will be supplemented to this case but you heard testimony in terms of the volunteer nature of the admission here, the pre-admission requirements here, and I'm certain that payment and resources are explored at that time. Operations can discuss that a little bit further. J, the only provision of this chapter that shall be interpreted as conditions are subparagraphs A or B or C in this section. Again, that's informational. We need all those conditions with the exception of the specific citation of the license number. And then finally, nursing homes and assisted living residences shall not be allowed or permitted as conditional uses in the RA or RB zoning districts. The nursing home was permitted in the OR1 district. This facility, again, a zoning equivalent of a nursing home, will be in an OR1 district. And through Mr. Bridges' letter, it specifically indicates that your ordinance does not define such a care facility. And as such, given the zoning equivalency, I think we are appropriately situated in a proper zone. So when we look at the standards here, but for the one distinction of the licensure number, we do meet every conditional standard for a nursing home. And you've heard my testimony in terms of how we are interpreted by law, and by established case law, as a zoning equivalent to a nursing home.
So do you believe that the proposed rehabilitation facility constitutes a continued use of that prior nursing home use?
Absolutely.
And that's based upon your analysis of the ordinance that you just went through, along with the impact of case law in New Jersey.
I would say not only the ordinance, the case law in New Jersey, federal case law in terms of protecting the class of citizen that would be treated at this facility and how those citizens are protected, and failure to protect those citizens would essentially be a discrimination of those citizens. And then finally, understanding through Mr. Bridges' letter that the ordinance does not specifically distinguish the use anywhere within the community, essentially creating a gap for the use within the community. I certainly believe that that's a distinction worth note. And lastly, in terms of parking, there was a lot of discussion about it. I would say the one distinction here with respect to parking as opposed to potentially a nursing home is that the patients here specifically are not permitted to drive. They will not be arriving in vehicles. They will not be receiving visitors on site. In my discussions with the applicant and Dr. Tarlow, and I don't think it came out in testimony this evening, but it is my understanding that not only are visitors in person discouraged, but they would, if visitation was to be permitted, it'd simply be limited to a Zoom or a FaceTime call so that there could be that kind of interaction, but it would not be face-to-face interaction. So if we're looking strictly at a level of staffing and even applying the percentage over as the ordinance requires, we have sufficient parking for the operation of this facility without resorting to building the green spaces and contemplating the fact that there are 20 green banked spaces available to this. I think the parking here is more than adequate for this facility to operate.
And finally, would you agree that the language as to the licensing requirement, the citation specifically provided, the distinction between the nursing home and the rehabilitation facility, utilizing that as a distinction between these two uses would be the type of distinction the courts have routinely rejected here, that functionally these two licenses are the same?
I do, and I think that, Michael, I think that's actually reinforced within the language of their very own conditional use requirements, whereas they give us a distinctive license for the nursing home care, but later on they refer to it as nursing home level care, which isn't distinctive to a specific license.
Thank you. Mr. Chairman, I have no further questions for Mr. Janow.
Board members, do you have any questions of the planner?
Yes.
Okay, yes.
Yes, I do. On the case law,
Yes.
I know you cite a couple in your report. You have said that the courts have continuously said that there's no difference. You probably about a minute ago said there's a whole lot of case law out there. Could you provide our attorney with a listing of all that case law, because we will be relying on her?
I specifically relied on the case law I cited in my report. Those citations are included in my report. And I'm sure your attorney has access to LexisNexis in terms of being able to download that. That's how I was able to get the case law itself. But certainly to the extent that there's any assistance required in terms of the case law, we'd be happy to help.
I can certainly.
Okay, thank you, because you're implying there's a lot out there. And you stated it's continuous.
And it's very specific.
Okay. Regarding the rehabs and health, and maybe this question for you, maybe for someone else, does health issue prior to a license early on a certificate of need like they do for a assisted living? I think hospitals where you have to demonstrate a need is really there.
So no, there is no certificate of need required here, but I will cite, and I believe it's in my report, there was a essentially declaration of emergency with respect to addiction and the need to provide addiction treatment. And I'm just looking to see where bear with me for a second, I'm looking for that citation.
Okay.
Yes, on page 11 of my report, where we talk about uses equivalent as a matter of law, there's a citation from the New Jersey Healthcare Facilities Planning Act, wherein it's specific that I'll just read you the first couple of lines. It is hereby declared to the public policy of the state that hospital and related healthcare services and behavioral healthcare services of the highest quality of demonstrated need, efficiently provided and accessible at reasonable cost, are of vital concern to the public health. It is further declared that integrated physical and behavioral health care is the most effective way to improve health of individuals of the population at large. In order to provide for the protection and promotion of the health of the inhabitants of the state, the Department of Health shall have the central responsibility for the development and administration of the state's policies with respect to health planning, hospital and related healthcare services, and healthcare facility costs. And it goes on to say that this relates to residential healthcare facilities, nursing homes, facilities for the prevention, diagnosis, care, or treatment of human disease, mental illness, substance use disorder, pain, injury, and deformity. So there is a declaration, and the New Jersey Healthcare Facilities Planning Act specifically gave the Department of Health the oversight for such facilities.
And I would just add briefly, and I know we mentioned it earlier, it's through that act that the regulations were promulgated for the license issuance, both for the nursing home use and the rehabilitation use, correct?
That's correct. And that's why there's a distinction in the way that's licensed versus assisted living.
And healthcare facilities under that act specifically is defined to include nursing homes, rehabilitation facilities, and hospitals.
Behavioral health and substance abuse centers. Yes.
Yes.
Yes. Essentially same breath.
My other question is regarding, and it might not be for you, but someone else, regarding market area that you envision for this facility. Where will you draw? Will you be drawing only locally, or is this statewide?
That's an operational question.
Yeah, that's what I thought. Could someone else respond?
Sure, I'd be happy to have Dr. Tarlow, if she's available, try to answer that question. Let's see, she's muted. Just trying to see. Dr. Tarlow, can you hear me?
Hi, yes, I'm here.
Okay, there was a question, Mr. Floyd, if you could, it may be easier if you can just repeat your question, please.
Yeah. Where do you plan on drawing your clients? What's your market area?
Hello, here I am. Can you hear me okay?
Yes.
Okay, the market area is the surrounding area of New Jersey, New York, the Eastern Seaboard. We have individuals who come to our facility from locally and all over the country. And on occasion, we have people coming from like, the Caribbean. But that's where we get our patients from. We would not turn anybody away. However, we also have, an admissions team that help to place people. So if they are not suitable for our care for any reason, that we then find them placement. And we also work with, Rutgers University and NJ SAMS and various other New Jersey state bodies that work with helping to reduce addiction and the collateral damage that occurs with it.
And I guess a question, perhaps for your attorney, maybe not. I asked that question because inherently beneficial, my experience deals with the immediate area.
Yes, absolutely.
Absolutely. So if you're going to maintain this as inherently beneficial, and you're drawing internationally,
well, on occasion,
multiple states.
So
I wanted to know that.
Mr. Floyd, I think what you're referring to is if we were seeking a use variance, the arguments in favor of this board granting that use variance under the inherently beneficial standard. That is not what we are requesting right now, but you are correct. That would be
okay. I didn't bring up inherently beneficial. You and your documents did.
Correct. Yes, because this is an inherently beneficial use, but ultimately that is not the relief upon which we are seeking a use variance here.
Okay. Thanks for clarifying that. It's not a pressure point on us.
Correct.
Thanks.
Okay, what's next?
So finally, we have a representative of the applicant and property owner just to answer a few quick questions. Mr. Carl Kaplan.
Hi, I'm here. Good evening.
Carl, you've been sworn in previously. If you could you please introduce yourself to the board and your relationship to this application?
It's Carl Kaplan, Karlkaplan. Live in Mahwah, New Jersey, 7 Fox River Crossing. I'm one of 4 individuals that is part of the partnership that owns this property.
Okay, and when did you purchase this property?
November of 24, we closed on the property, but we had been, I guess, looking at this property for about a year, a little bit after it had unfortunately closed.
Okay, and can you explain some of what interests you in this property back when you were looking at it?
Sure. I think part of it goes, I have a relationship with Boca Recovery where they're a tenant of mine in a new facility in Englewood, New Jersey, property that I own. And just getting to know them, the people they are, the individuals that they're serving, and understanding that they were expanding into Massachusetts and Indiana. And I always ask them, why are you not expanding more here? There were some statistics that were shared with me maybe 2 years ago that in New Jersey alone, there's only about 13% of the beds available to satisfy the need. And I said, why don't you find anything here? And they said, well, it's difficult to go and build out a new location. If we could find a nursing home, okay, it's good. That's what we did in Massachusetts. That's what we've done in Indiana. So when this property became available, we started discussing that with them. They had some other projects that were going, but they had agreed that this would be a good location for them. And based upon the prior use, that it would be something that would satisfy their needs.
And again, that's coming from the fact that as an institutional medical use, it meets many of the criteria that's required for the type of use that they were proposing at this site.
That's correct.
Okay. You heard testimony as to the prior 1999 approvals, the conditions of that approval, landscaping, stormwater improvements, etc. Obviously, as part of any establishment of this proposed use, you will, as property owner, update the landscaping to meet that prior approval, perform any on-site maintenance that's required in order to, again, bring that site, that now vacant site, into the modern age and beautify it as needed, correct?
Yes, that's correct.
Okay. Mr. Chairman, those are all the questions I have for Mr. Kaplan.
Board members, any questions of Mr. Kaplan? Okay.
Thank you for your time.
Okay, does that conclude your presentation?
It does, Mr. Chairman. I would just ask for a brief summation following the public comment portion.
All right, board members, do you have any questions of the applicant, the witnesses, the landowner? at
I
this
have one
time?
quick question, Steve.
Sure, yes.
Are there any equivalent centers like this in Princeton now? Are there drug treatment centers in Princeton?
Princeton House, which is run by the hospital, Penn.
It's on Harrontown Road, Stephen.
Yeah, it's right in that same area.
Right.
What about the one on the Great Road? Is that a drug?
Talking about
Yes.
10 acre?
10 acre?
So it's a foundation. I don't know what it does there.
Okay, it doesn't matter. I'm just curious. Thank you.
I think there's nothing this big. I guess I thought maybe the applicant will have surveyed, but there's a few small ones around in West Windsor, Monmouth Junction, a couple other places as far as in this area, but you know.
Michael, are they group homes or are they?
No, they're drug rehab. Are they living? What are you asking? Excuse me. I'm clarifying.
Are you asking me?
Yeah, I mean.
No, I just wanted to know.
I don't
you
know what you
cited
mean
the-
by group homes, I guess is what
Oh,
I'm.
group homes are just, vary for 6 people, something like that.
The ones some look like 20, 25. I didn't see any
Okay.
big structures, and they're usually 1 story or 2 at best, small 2-story. But just a little bit of research I tried to do.
Thank you. Okay, board members, any other questions or comments before we allow the applicant to sum up and we go into public comment?
We take a quick break, please.
That's fine.
5 minutes.
It is 10:02. We'll reconvene at 10:07. Thank you.
Hey. Mike. Hey.
Okay, it's 10:07. I guess we're missing Bernice and Harlan is. Okay. We're back in session. So, Mr. Lario, are you there?
I am, Mr. Chairman.
Okay. All right, so we finished your witnesses. Board members, do you want to ask any last questions, any final questions before we allow Mr. Lasko to sum up and we go to public comments?
Mr. Chairman, if it's
Yes.
okay with you, just in case there's any questions or concerns raised during the public comment portion of the meeting, I would appreciate the opportunity to summarize the application following public comment.
Yeah, typically after public comment, we allow you to make a closing statement before we go
Yes.
into executive session.
Perfect. Thank you.
Okay, all right. And just for informational purposes, we stop at 11 o'clock. Okay, it's 10:08, so
Okay.
plenty of time. Okay, so if you don't have anything to sum up on now before we go into the public comment, then I'll open the hearing up to the public. Claudia, has anyone indicated they want to speak on behalf of this application?
Yes, Mr. Chen, Eric Chen.
Yes, yes, this is he. Hi, good evening, everyone. Hi, my name is Eric White Chen, and I'm the owner of 7 Campbell Wood
Hold
Way.
on 1 second, we can't see you.
Oh, okay, hang on. Well, can you see me now?
Yes.
Hi, Mr. Chairman and the zoning board and everyone. Thank you for your time, and I'm the owner of 7 Campbell Wood Way in Princeton. And I do
Sir,
have.
1 second, you need to be sworn in.
Karen, you
Okay.
muted. Karen, you're muted.
Very sorry. My apologies. Mr. Chen, do you swear or affirm your testimony this evening will be truthful?
Yes,
Thank you very much.
thank you. Yes, I just want to speak on behalf of my neighborhood. I just oppose this application simply because of common sense. That first, the patient's structural differences. We all know that nursing home is serving the elderly and disabled person, especially the elderly person, versus the younger drug or alcoholic addict, which may include the violent, tendency of people that are coming into this facility. Secondly, is safety, 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 location, location, location. Okay, and the third is a concern to the community, to the neighborhood, and most importantly, the property value of all the Princeton Township. And that's my three major concerns. And I do have a question for the owner, Mr. Kaplan. What is your next step if your application has been denied before the zoning board? Because you already purchased the property. So what's your next step if you can repurpose into this substance treatment facility? Thank you.
Well, I wouldn't expect that the board would deny our appeal. So we haven't given consideration to that, seeing the facts that were laid out. I would have to discuss that with council.
Okay.
Any other comments? Mr. Chen?
No,
Thank you.
that's it. Thank you.
Claudia, has anyone else indicated they'd like to talk on this application?
Mr. Vasquez?
Yes, good evening, Miss Casey. If you could swear me in, please.
Mr. Vasquez, are you comfortable giving your address?
Yes, I am. I'm a resident of 7 Campbell Woods Way, the Campbell Woods development that's directly due south of the proposed project.
Alrighty, and do you swear or affirm your testimony this evening will be truthful?
I do.
Thank you.
Yes, good evening. I want to thank the board for their service. I want to thank Mr. Larry for his presentation. I want to go on the record stating that I support Mr. Bridges' interpretation of the current zoning. I would also like to bring to the board's attention, as a practicing litigator for over 25 years, that a lot of the experts that were opined today were not subject to cross-examination. And in my opinion, strictly as a tenant, they spoke outside, they opined on legal issues, they cited case law. They're not registered attorneys, they're not licensed attorneys. They cited law that is over 30 years old in some cases. We don't know if that case law is still valid, has been subjected to different interpretations. So there's a lot of questions based on Mr. Lario's presentation that I have, but it's not my position at this particular point. It's the board's position to ask these tough questions. A lot of these experts were not subject to cross-examination based on a lot of the opinions that they cite, a lot of alleged law, alleged zoning. And again, these are a lot of questions that I walk away with. And again, the best evidence that we have here is Dr. Janlau's testimony, that what she said does not sound by any reasonable interpretation like a nursing home, at least the way I know it by having had friends and relatives in nursing homes. Also, what Mr. Lario would have us believe is just because we're licensed because they would be under the supervision of the New Jersey Department of Health, that automatically gives them leave to get an approval by this board. And that's not the case. That's not a reasonable interpretation, at least from a layman's point of view, because that would lead the New Jersey Department of Health, for example, licenses over 20 different types of facilities, from acute care facilities, ambulatory facilities, hospitals. So under his interpretation, any of those types of facilities would be able to be built and put into operation just because they're under the supervision of the New Jersey Department of Health. And I don't think, as a layperson, that's a reasonable interpretation. And that's why I support Mr. Bridges' interpretation. That would be leading, if we were to believe Mr. Lario's logic, that anybody licensed by the New Jersey Department of Education would be able, a mathematics teacher could teach a Spanish course, or a physical ed teacher could teach an English course, just because they're all licensed by the New Jersey Department of Education. And that's strictly, I think, from a common sense point of view, not a reasonable interpretation. I've heard Mr. Bridges' report. I've read it, and I think it's reasonable, and I think it would withstand, from a layman's point of view, any type of scrutiny. Also, Mr. Lario tries to intimidate this board by bringing up, well, not just Mr. Lario, but his expert, claims of violations of the ADA and court costs and all these types of attorney costs. That's not the point we are here. We're strictly based on the four corners of this appeal, and that would have to be discussed and judged in any type of future litigation and or appeal before a judge or a jury. So I think those allegations that Mr. Lario brings up this particular one are premature and misguided by trying to kowtow and to try to intimidate by bringing up those points which are not necessary at this point in the presentation. So with that said, I fully support Mr. Bridges' interpretation. I think it will withstand scrutiny by a reasonable trier of fact. And I, as a resident due south of the adjoining development, do not wish to have this type of use approved because it does not fit the interpretation that Mr. Bridges says. It's not a nursing home. And if we look at Dr. Janlau's, it doesn't sound like a nursing home. And to use the old adage, you know, it's just not, it's not. So once again, with all due respect to Mr. Lario and his experts, I highly disagree, and I think that if his presentation was subject to cross-examination in either an arbitration or a courtroom, a lot of this testimony and a lot of his facts would fall apart, especially his citation of 30-year-old or 35, even 1972 case law. With that said, I want to thank the board for their time, for their volunteer work, and for their service to our community. And once again, I ask this board to reject the appellant's application based on the reasons and the reasons and logics found in Mr. Bridges' report. Thank you so much.
Thank you. Claudia, has anyone else indicated they'd like to speak?
There are no more hands.
Okay. All right. Since we have no more hands up, we're going to close the public portion of the hearing. Mr. Lario, do you want to make any closing comments before we go into executive session?
Yes. Thank you, Mr. Chairman, members of the board. One quick procedural issue before I get to my closing statement. I think there was a question as to the parking demands for this proposed use, given the number of employees. I think your zoning officer raised a question as to whether or not that would be in conformity with the ordinance, with the number of beds and anticipated number of employees, and whether a variance would be required. What the applicant would be willing to do is provide a detailed zoning analysis to the zoning officer indicating compliance with the ordinance requirements by way of parking calculations. And if ultimately, in order to comply with the ordinance requirements as to parking and not seek a variance, there has to be a reduction in the total number of beds or total number of employees, that's what the applicant will have to do. Ultimately, we are not seeking a variance tonight from this board as to the number of beds. We're seeking a continuation of the previously approved use, and we will be able to provide that documentation to the satisfaction of your zoning officer that no variance is required as a condition of any approval granted by this board. Over the course of tonight's presentation, you've heard testimony from our professional engineer, you've heard testimony from our licensed clinical psychologist, our planner, and a representative of the applicant and property owner. These witnesses have confirmed that the proposed use of this site, the use of the site as a licensed subacute non-hospital-based drug and alcohol rehabilitation facility, falls squarely within the previous zoning framework of the nursing home use and is in both form and function equivalent to that previous use. And again, I think it's important to note that is not my opinion, or that is not Mr. Janow's opinion. That is New Jersey reported case law, which indicates that these uses are the same. The property was purpose-built for institutional care. The building includes patient rooms, nurses' stations, kitchen facilities, medical infrastructure, all support areas consistent with a high level of residential health care. Importantly, the applicant is not proposing any changes to the exterior of the site, no changes to the building, the footprint, circulation, access points, parking, all will remain consistent and compliant with the OR1 zoning standards and the plans previously provided to the planning board in 1999. And I would suggest to this board that is not a coincidence that there are no site changes required here. The reason is because a nursing home use and a rehabilitation facility are viewed the same under the regulations and existing case law. As you've heard from our professional witnesses, the proposed use involves the same level of 24/7 medical supervision. It's licensed by the New Jersey Department of Health and operates under the same regulatory framework as the prior nursing home use. The only material change here that we're talking is the license that's issued, and that goes directly to the patient population served with the proposed use. There's no change to the nature, intensity, or structure of the use. From a zoning perspective, there is no meaningful difference. It's a continuation of what was previously approved for this site. It is not a new use. We respectfully submit that the zoning officer's February 26, 2025 determination that this proposed rehabilitation facility constitutes a change in use requiring new site plan and conditional use approval misapplies the law, and we would ask that this board under 40:55D70A correct that misapplication. Now, obviously, in addition to the functional and legal equivalency of these two uses, our planner testified that the proposed rehabilitation use complies with all conditional use standards set forth section T10B 27240 of your ordinance. While the licensing citation may differ, both licenses are issued by the Department of Health. They impose operational and care standards, and they're heavily regulated and inspected by the New Jersey Department of Health. Again, I know we keep reiterating this point, but I think it's critical that the license citation and the class of people served by this use is the only thing changing, not the actual regulatory framework and supervision required under the law. Additionally, both nursing homes and rehabilitation facilities represent the same inherently beneficial institutional use class under New Jersey law. To deny compliance simply because a regulatory citation in your ordinance differs between a nursing home use and a rehabilitation facility, while the function, supervision, intensity all remain consistent, would be inconsistent with applicable New Jersey case law. As was stated, there are important federal protections implicated by this application. And again, I don't bring that up to threaten the board. I bring it up because it's my responsibility, and I bring it up for the board's benefit. The Americans with Disabilities Act, Federal Fair Housing Act protect the specific class of people at issue here. To not deny this proposal based solely on the fact that the citation differs from a nursing home use to a residential rehabilitation facility when every other material aspect of the proposed use remains unchanged would constitute, we believe, discrimination under federal law. The proposal before you this evening will restore a vacant building into a productive use, a use that is desperately needed both this state, in the area, nationally, to meet a critical public health need. It's going to do so without burdening the surrounding community in any way or increasing site intensity. There's no conflict with local zoning ordinance. We're not seeking any variances as part of this proposal. We're not proposing any change to the physical condition of the building. And no, there's no legitimate reason to impose additional regulatory hurdles on the applicant to apply for conditional use variance relief and site plan approval when the use itself has consistently been found by New Jersey courts to be a continuation of what was previously approved at the site. In short, it is our position that what we are proposing is supported legally, practically, and equitably. For those reasons, we respectfully request that this board overturn the zoning officer's determination and confirm that the proposed use of this site constitutes a continuation of the previous approved use, and the requirement for a site plan and conditional use approval is no longer required. I thank you for your time and attention tonight. If there's any additional questions, we're happy to address them. Thank you.
Thank you. Board members, before we go into executive session, do you have any questions of the applicant witnesses? Okay.
Mr. Chairman, I would say just before, I understand you're about to go into executive session. I just want to make clear, I guess, clarify exactly what the board will be deciding on. I think what we are appealing is the determination that the proposed facility does not constitute a continuation of the previously approved use. I think that's the critical inquiry before the board right now. So I would ask, as the board considers the presentation made, that's ultimately what we are appealing, because if this is found to be a continuation of that previously approved use, I think ultimately no site plan, no conditional use standard is required. I believe that is the question for the board. We are agreeable, as I stated, certain conditions, including providing documentation to the zoning officer indicating conformity with the zoning ordinance, parking requirements, but essentially the question is whether or not under New Jersey law this constitutes a continuation of what was previously approved.
Thank you. Karen, I have a question.
Yes.
If we find that this use is a continuation of the other use, what action, other than saying we agree with that, do we take this evening?
I
And
think all right, this evening you would say that you are overruling the zoning officer's interpretation, that you find it's a continuation of the nursing home use, and that they do not need a site plan, nor do they need a variance. And the variance being a deviation from what the ordinance governing nursing homes in the zone, what the condition of the nursing home license. So what you'd be say, if that's what you find, then you would be saying you're overruling the zoning officer's interpretation, and they don't need a site plan because they're not changing the use, nor do they need any variances.
Would that mean that Mr. Bridger would have to sign off on this and allow it to move forward without?
Correct. I mean, I think the applicant has said they're willing to condition that on providing a parking study to Mr. Bridger. I'd want Mr. Bridger's input on that. They're saying if it turns out the parking doesn't comply or their study is not compliant, they are willing to reduce the number of beds to get to a point where it is compliant. I think I understood that correctly, Mr. Lowry. Is that what you said?
That's correct. Obviously, if the board were to find this is a continuation of previously approved use, there's certain leeway with the parking demands, but we need to comply with the ordinance. And you have an ordinance which sets requirements for this type of use and the associated parking demands. What we are saying is we will comply with that parking demand, or we'll submit an application for a variance. But either way, we will ensure that what is being proposed here meets what your ordinance requires to the satisfaction of your zoning officer.
I had another question, Karen. Mr. Lasko brought up the fact that he didn't have adequate information to review the application. If we, again, assuming that we agree that this constitutes a continued use, would that negate the requirement of not requirement, for the suggestion of Mr. Lasko that he get the necessary paperwork to review the application?
Well, I think so, because if your finding is that it's a continuation of the prior nursing home use and that they don't need a variance or a site plan, then I don't know what Mr. Lesko would be reviewing at that point. I mean, you tell me, Justin, if you disagree with that. Do you feel that if that's what the board determines?
Then there's no further information that goes to me, except
Right.
in the case that we just discussed, which, I guess it still wouldn't necessarily go to me. It would just go to Mr. Bridger. But the case that we just discussed was you would be determining it's a continuation of the existing use, while at the same time determining it's different enough to have a study or potentially a variance. That sounds a little, I don't really understand the logic of that one.
So if I may, ultimately what we are proposing is if it is a permitted use within the zone and there is a change that impacts parking demands, but it is still consistent with your ordinance and existing parking, that does not require by itself a site plan application or a change in use application. What we are saying is any change to parking will comply with your ordinance requirements. If it doesn't, we'll either have to submit a variance application or reduce the bed count to a way that does comply with the existing number of parking spaces the planning board approved back in 1999.
You're basically asking us to approve this, and then you would submit information which may result in a change in your application.
What I'm saying right now is any approval granted by this board can be conditioned upon conformity with what your ordinance requires by way of parking requirements, just as you would require for any applicant that's not seeking a variance.
The only difference, Mr. Larry, is that normally the board would have information about parking. I mean, that would be something that they would have asked for, the staff would have asked for. So, I mean, another alternative would be to carry this so that the applicant can provide that. And then that point, the board could make its decision. That's another alternative, so that staff has seen it and can respond.
So ultimately, though, the question is whether we comply with the ordinance or we don't. I mean, that's the legal question where if we are below the number of the 80 parking spaces that is approved for this site, I would say that no variance is required and this board can grant that relief. If we're over it, that creates a problem. What I'm saying right now is we will not be over that 80 or we'll have to come back before this board.
And that 80
still-
includes the banked parking spaces too.
What was approved, correct, yes.
Okay, so we're potentially talking about changing the physical layout of the site as well.
Pursuant to an approved site plan, yes.
Okay.
To a previously approved site plan or a newly approved site plan?
Previously approved. The bank parking spaces were part of the 1999 approval.
But they would create impervious coverage, and the ordinance on impervious coverage has changed dramatically since 1999.
Again, it's an approval that's, I think, arguably that's a different question as to whether or not it's vested.
That's why it's a site plan. I mean, it's, could have filed one. And I'm just concerned that you don't know what the parking demand is. It was brushed over very quickly, and when I asked a follow-up question, I didn't get a clear answer. There's conflicting data from your doctor, who I would expect would be the expert in that, with the engineer. And I haven't got an answer for that, and it seems like you're punting it, and you've had since February. You basically submitted the same application as a zoning permit for the appeal of the interpretation. So it just seems like that information is not provided is somewhat troubling.
So ultimately, because it's continuation of a previously approved use, and we are not proposing right now to go above what the ordinance allows for parking, we're not seeking a variance. I think your question is to, well, what is the parking demand going to be? Obviously, we can't go above the 80 parking spaces that were previously approved. So it will be a maximum of 80 parking spaces will be the demand.
I just don't understand why you did all the other research and you kind of scuttled over that important piece of information.
Again, I think we've determined a way in which we can address the concern as to keeping the parking demand within the 80 spaces that are provided for in the approved plan of development.
So in a way, I guess what's being proposed is kind of bifurcating the application to be about whether the licensure use allows it to be a continuation of what was approved, but we're bifurcating out whether the parking study conditional use requirement is met. And then we're putting that to staff potentially to determine rather than the planning board or the zoning board.
So I would agree that
Yes.
the introductory legal question is whether or not this constitutes a continuation of the previously approved use. If ultimately it is, then it becomes a question as to whether or not the parking demands associated with this use trigger the need for variance relief, or whether the applicant can rely upon the parking spaces that were included as part of that original approval. What I'm saying is we will provide documentation indicating that we are compliant with the parking provided for in that 1999 approval.
But if the conditional use is based on the parking study and the parking requirement
It's not.
from 1999, it's not. Isn't that the standard that was mentioned in Mr. Bridger's memo T10B 272.44? And then that's where it goes into the number of nursing care beds, staff members, all the questions that we've been asking.
So that's a site plan requirement. It's not a conditional use standard. Conditional use requirements under the ordinance.
Question for staff. The 1999 approval is now what, about, my math is right, 26 years ago. If there was no question being raised, let's say another nursing home took over and they said, we need the 20 banked spaces now. We need them. We have more staff. issues such as impervious coverage and stormwater management and drainage, is that something that you would be raising in that situation?
Yes.
Okay.
And I would say ultimately, if the use is confirmed as a continuation and that becomes an issue as to the impact on impervious, that's a separate conversation that we can certainly have. I mean, I'd have to look into those approvals, but then you're talking about a site plan for a continuation of a permitted conditional use.
No, we'd be talking about a site plan because you want to add 20 extra parking spaces, correct?
Yes, but ultimately, if it's found determined to be a continuation of that 1999 approval, it's a continuation of that previously approved conditional use and then a corresponding site plan application, which is different than the appeal before this board, which challenges the determination that D3 variance reliefs required.
Well, let me phrase this. If this is carried to, I'm not sure what date, and if the parking information is provided to staff, that would eliminate this question, wouldn't it? Eric, Justin.
I guess it depends on the information. What are we gonna
Oh,
get?
no, I understand. No, I understand that. But what I'm saying is it would provide a basis now to assess whether this is an issue at all or whether it's not.
Correct.
Yeah, that's correct. I think the reason that I've been asking so much about staffing is because the parking is based on the staffing. So if we had that number and then could deduce the number that Derek was getting at earlier, then we could compare it to the existing approval.
There appear to be the two separate issues. One is the continued use and the other, I guess the sub issue is the parking. And, but it would seem to me that we need to resolve both and we need to get the information on both before we can make a decision. Is that correct?
Mr. Chairman.
Yes.
Chairman. My thoughts or my opinion is I've heard the testimony. I understand things. I understand Mr. Bridger's memo because it was short and sweet and very, the four corners of the ordinance. And his decision, in my opinion, was correct. Now, the whole debate regarding continued use, quite honestly, I'm used to seeing after a discussion like this, not with the zoning board, but in my past profession, a confidential attorney's opinion letter by the board's attorney looking into this whole basically threshold issue. That can only be resolved, in my opinion, with a continuance and consultation with Karen. That's where I am. I mean, a drug and rehab is not a nursing home, is not an assisted living. Assisted living is not a nursing home. I've been involved in the financing of 10 assisted living jobs. I've dealt with health, so we got to get over that hurdle. And I'm doing it, or would like to do it, in consultation with the board's attorney. That's all I have to say. I think it ought to be continued.
I actually agree with Michael, because my next question was, Karen, was a confirmation that the case law and all the comparisons that the applicant has, brought forth during this thing are accurate. So, I mean, that's my question, which is exactly, I believe, similar to what Michael's saying.
Yeah, and what were the opposing arguments? Or were there some opposing decisions that don't support the applicant? I don't know. But I'm not voting one way or the other without an attorney opinion letter.
I agree with both Michael and Stephen. I do not in any which way, shape, or form think that counsel or the witnesses have deliberately misrepresented the law. I don't believe that they would do that. I do think it would.
I'm not suggesting that, by the way.
Nor am I. But I do think it'd be prudent for us to make certain that that we have the answers that we need, and we don't solely rely upon what's being presented to us. So I completely agree with an attorney letter on this.
If I may, I see, I'm sorry.
1 second.
Yeah, not a problem.
Wait, no, go ahead. I was mentioning that to Bernice. Do you want to?
The only thing I would add, and I understand some of the concerns, but I would just put on the record, obviously, from the applicant's point of view, this site is sitting vacant right now. They're unable to do anything with this property while this works its way through the process. The application materials have been on file. I think the question as to the accuracy of the legal citations provided in the planner's report and discussed on the record, if there is a question as to the accuracy of it, I'm sure everything has been reviewed by your professionals. We can certainly raise that now, but I'm just, and I can talk to my client, but I think it's going to be hard for us to be agreeable to allow additional time for this when this has obviously been on the agenda for a while. And again, I would just say,
Mr. Mario, if you don't allow additional time, then you may not be happy with the answer we come up with this evening. So if that's a risk you're willing to take, then by all means. But you may not be happy with the result.
I understand. And I'm sure you understand that it's.
I have a question for Karen.
I'm sorry.
With the appeal process, Karen.
Yep.
I know we had to hear this within 20 days or something.
Well, they had to, yeah.
But do we have to come to a decision tonight?
I don't think so. And
then why do you need to discuss it with your,
I think, Mr. Lario, you're taking the position that your client would need to. I mean, ordinarily, if the board seeks more information and they want to carry it, they would take that action. If you're saying
also
that,
10:45.
Well, that's true.
We can carry it.
Are you saying that you want to force the board to make a decision tonight? That's what I'm hearing.
All I'm saying is I'd like the opportunity to discuss with my client before I take a position one way or the other. And I understand that adds a little bit of a wrinkle here because we're in this virtual format, but a few minutes for me just to converse with my client and make sure there's no issues, and then I can report back to the board.
What's the board's pleasure here?
Well, I mean, look, we are going to wrap it up at 11. If you want to take a couple of minutes, I don't have a problem with that. Board members, what do you think?
Yeah, I think it's fine.
Sure, but yeah, I just wanted to add, in addition to other information that we haven't, that we don't have, we don't have any information on, I know that you're saying the building is not essentially going to change. What about the use, the outdoor space? I would imagine that the type of facility you're proposing is different from a nursing home where people aren't very ambulatory. They're probably much more confined, and part of the therapy might involve use of outdoor space. So just understanding a little bit of that would be helpful.
Understood. And that's certainly something that we can provide that information to you.
I would like to also add something that I just kind of realized in the last couple of minutes in the discussion, which is the, that we have heard from you and others that there is not and should be no distinction between the what we might think of as a nursing home population and the population of a treatment center that you're proposing. But there is one distinction that we've heard about all night, which I saw in your report, which is how many parking spaces are needed. And it strikes me that if for some reason you decided that a treatment center wasn't viable, or that you didn't want to be in that business anymore, if those two populations are interchangeable, you might say, okay, well, I think we're going to do it seems to me you'd be within your rights to turn it into a nursing home, but then you'd need more parking. So it is kind of, it's the same, but it's not the same in materially and how you would set up the building. So I think it's something we need to have a chance to understand better. And
I'm
shouldn't
sorry.
be heard as us discriminating.
And I think in response to that question, I understand the inquiry as to how parking demands could change. And I think, as I stated in the beginning, municipalities, while they can't differentiate these uses from a zoning perspective, they can regulate it. And you have a zoning ordinance on parking on the books, which talks about how you compute the minimum required parkings for these types of uses. Now, again, a drug and alcohol rehabilitation facility is nowhere in your ordinance. So you look to the next closest use, which in this situation is a nursing home. We believe, and what we've put on the record is we'll comply with those requirements. But I understand, though, and that's why we're willing to agree as a condition to provide that documentation establishing conformity with that ordinance, because we have to.
I think we're just asking for the information now before we make a decision. We're not saying we're not going to approve it. We're not saying we are going to approve it, but we just want the information that we questioned during the hearing.
So if I, Mr. Chairman, can I take one quick minute?
Yes, okay, let's, it is 10:48, let's say 2 minutes work.
Mr. Chairman, again, I appreciate the board providing me with that time to speak to my client. We understand the concerns, the request from the board. We can provide the parking information that's required if the board elects to carry this to another date. I know a special meeting was chosen for this hearing. We would just ask, if at all possible, I know the board is very busy with the queue of applications, if the same courtesy could be provided again and a special meeting be scheduled, fitting within the schedule. I know it's summertime and everyone's busy. That would be greatly appreciated on behalf of the applicant.
When will you get back to us with the information we're asking for?
So I would say we want it on file at least 10 days prior to the meeting. And we probably require at least 2 weeks to assemble it. So I guess.
Well, would it, Mr. Bridger, Karen, would it be acceptable just to hold the date open until we see when we get the information? And then again, you'll have to look at the schedule and see when the next available time we can either have a
Well,
special meeting.
if we can't carry to a date certain that can be announced tonight, then the applicant will have to renotice.
And,
So we're
and we,
trying to find a date certain so they don't need to do that.
we'd prefer, obviously, Mr. Chairman, not to have to renotice for this application if at all possible.
Can I speak to the scheduling?
Sure, please.
So we have a special meeting in July and a regular meeting. And the regular meeting at that case times out, it's a site plan. I think they're gonna give us an extension. I'm away for the first 2 weeks of August. I mean, I think the next available meeting, and I'm not trying to delay this, Mr. Lario, would be the August meeting, which would be I believe the 28th, 27th.
Oh, I think it's
excuse
the
me.
27th.
You're correct.
And obviously, Mr. Chairman, that gives the applicant pretty significant concern here. Is there any way the meeting's in July? We're not going to have to go through the same testimony again. I think the questions that are being asked as to the legal citations provided and the parking analysis, it really shouldn't require the level of discussion that's taken place tonight. I would ask for the board's consideration in allowing us to try to get through this information at one of those July meetings.
Eric, we have 2 meetings scheduled in July
We have
now.
the 16th.
And the 23rd.
We could do the 30th, possibly.
Members, are you agreeable to 3 meetings in July?
I can do it.
Sure.
I'm okay with it.
Yeah, it should work.
I can do it.
I can do it.
Michael, are you available?
What's the third one?
The 30th?
The 30th.
Oh, okay, I was on the wrong month, excuse me. Sorry.
That would mean we have a special meeting on the 16th, a
Yeah,
regular meeting on the 23rd, and a special meeting on the 30th.
yeah, I can do it.
Correct.
Yes.
Valerio, is that acceptable?
It is, Mr. Chairman. I just want to specifically thank all the board members for your cooperation and flexibility here. It's greatly appreciated by the applicant.
We get overtime pay for the special meetings.
Hey, you know, that'll be right around my 10th anniversary on the board, so, you know. What a way to-
Okay.
All right, so for the benefit of the public, this application is now being carried to July 30th, and it would be 7:30,
Correct.
correct? Okay.
All right, so I guess that's it. Thank you very much, board members. Mr. Lario, thank you and your team. And we'll be waiting for the information you're going to provide.
Understood. Thank you, Mr. Chairman. Thank you, board members, and we'll see everyone in July.
Okay, thank you.
Thanks.
Good night all.
Good night.
Good night.
Thank you.